1 minute, we're almost live. Okay, we're ready.
Thank you. Good morning. Welcome to the Judiciary Committee public hearing for Monday, March 15th, 2021. Before we get underway, any comments from my co-chair or ranking members?
No, thank you. Good morning.
Good morning. Seeing none, let's get underway. We'll begin with the Chief Justice, Richard Robinson. Chief Justice, you have your 3 minutes, and we will probably have some questions for you.
Thank you very much. Good morning, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein. My name is Richard Robinson. I am the Chief Justice. Thank you for this opportunity to testify in support of SB 988, an act concerning judicial compensation. This bill implements, the recommendations of the Connecticut Commission on Judicial Compensation, which was established pursuant to Section 5147C of the Connecticut General Statutes, to examine and make recommendations with respect to judicial compensation. I want to begin my testimony by saying that I, as well as the judges serving the state, are acutely aware of the difficult economic climate, as well as the unprecedented pandemic that is causing additional financial constraints. I support the Commission's recommendations because I believe that they are reasonable and affordable. The Commission recommended, and the bill contains, an increase in the salaries of judicial officers of 4.5% effective on July 1st, 2021, and an increase effective July 1st, 2022, consistent with the preceding year's Consumer Price Index for all urban consumers, with a floor of 2.5%. The Commission recommended the same index increase for fiscal year 24 and 25, but the increases are not reflected in the bill because those fiscal years are not in the biennium. As the background, the state requires the Commission to take into account all appropriate factors, including but not limited to 7 specific factors. 1, the overall economic climate of the state. 2, the rate of inflation. 3, the levels of compensation received by judges of other states and federal government. 4, the levels of compensation received by attorneys employed by government agencies, academic institutions, and private and nonprofit organizations. 5, the state's interest in attracting highly qualified and experienced attorneys to serve in judicial capacities. 6, compensation adjustments applicable to employees of the state during applicable fiscal years. And 7, the state's ability to fund increases in compensation. The statute also requires the Commission to recommend compensation levels for 4 years, and that it also submit a report of its findings. The Commission reviews all of these factors, obtained data, invited public comment, and determined the Connecticut judges' salaries lag behind in all categories, including the rate of inflation, the levels of compensation received by judges in other states and federal governments, the level of compensation received by attorneys employed by government agencies, academic institutions, and private nonprofit organizations, and compensation adjustments applicable to employees of the state during the applicable fiscal years. The Commission concluded there was persuasive evidence that the relatively low pay for judges has made it difficult to attract experienced lawyers, particularly from private practice. That although the proposed salary increases would not fully bridge the salary gap, it is a measurably positive first step. I agree with the Commission and have noticed that there are fewer judges coming from private sector, and that it has become especially difficult to recruit judges of color from private law firms to join the branch. For the committee's information, the last time the judges received an increase was July 1st, 2019. This 3% increase was originally scheduled to go into effect on July 1st, 2016, but the General Assembly delayed that increase to July 1st, 2017. The judges did receive the 3% increase on July 1st, 2017. However, the General Assembly rescinded the raise on November 2017, bringing the judges' salary back to the 2015 level. The General Assembly then reinstated the 3%. Yes, sir.
Just so you know, your time's elapsed, so if you could summarize, that would be great.
Thank you very much. Actually, that would be a great point to summarize. I also want to note that I did submit a bill about court ops, and Judge Albus will be talking about the family issues when he testifies. Thank you for your time.
Thank you very much. Good morning, Representative Staffstrom. You have the floor.
Good morning, Mr. Chairman, and good morning, Chief Justice Robinson. Good to see you. Thanks for joining us bright and early on this Monday morning.
Thank you.
If you could just remind the committee, what is the salary for a Superior Court judge? right now in Connecticut?
Off the top of my head, I do not recall. It's about 186, I believe.
Okay. And do you have any knowledge of what a district court judge, a federal judge in Connecticut makes?
No, sir, I do not. But I did have the testimony, and I did talk to the Judicial Compensation Committee as well as the chair.
Okay. It's my understanding that district judges make about 220. So there's a significant salary gap between superior court judges and district court judges.
Yes, sir.
We received some testimony, I believe, from the trial lawyers on this bill that said Connecticut actually ranks 44th out of the 50 states in terms of judicial compensation. Is that, to your knowledge, is that accurate?
That is accurate if you factor in the cost of living. If you look at the straight salaries, it doesn't look that way. But once you factor in the cost of living, yes, that is accurate.
Okay. All right. Justice Robinson, while we've got you before us, one of the other bills you didn't mention, and I had sort of suspected you were going to touch on today, was the recommendations of the jury selection task force.
Yes.
Did you want to make a comment on that, or?
Thank you very much for this opportunity. I was trying to say a lot of things in a short period of time, but that is probably one of the most important pieces of legislation that can come out of the legislature this year. And the reason why I say that is because all those things are about access to justice. We know how bad 2020 was for the pandemic. We know how bad it was for the social unrest. A lot of what's going on is people have lost faith in our governmental institutions. And in particular, the thing that I worry about is the judicial branch. This is a way of getting people to be able to participate more in the whole federal process, judicial process rather, including participating in jury duty. We have a constitutional right to have a jury of our peers. A lot of people aren't feeling that that is the case. That bill will address a lot of those issues.
Thank you, Judge Ruchowski.
Thank you.
Thank you, Representative Stastrom. Good morning, Representative Fishbein. You have the floor.
Thank you, and good morning, Chairman. Good morning, Chief Justice Robinson. It's nice to see you again.
You too, sir.
Just during your testimony on the compensation bill, you had mentioned that fewer judges are coming out of the private sector, and recognizing that there's a variable there. The governor selects a nominee from a pool. Is it my understanding that less individuals are applying to become part of that pool? There is a difference you would recognize.
Well, let me put it this way. I've talked to the lawyers, and I know people who are interested in applying. I know people who are not interested in applying. And one of the reasons they are not interested in applying is because of the tremendous hit they would take in compensation. Being a judge is one of the most wonderful jobs you could ever have, especially here in the state of Connecticut. I would highly recommend it to everyone. But when it comes to that issue, I do talk to them. I'm honest about it. You have to be prepared to accept the salary of a Connecticut judge. And a lot of folks are willing to do that. Some folks are not. We have a more diverse bench than ever before. One of the places where I'd like to keep it diversified is not just people of color, not just gender, but people of a younger age, that middle age of lawyering. I'd love to attract more people at that level. The way it is now, we won't be able to effectively do it.
Well, thank you. Have you gotten like actual stats from the Judicial Review Commission, or I think that's the name of the group, that indicates the number of applications from the private sector as compared to other sectors?
I know they keep stats. I know I've seen them, but I cannot tell you off the top of the head the last time I looked at them. I know those kinds of stats exist. Okay,
because not that I currently have those aspirations, but I know that I applied in the past, and coming from the private sector, and I know that others in the private sector had applied, and we just get a one-page letter saying, no, you're not suitable. They don't tell us why, and maybe that's part of the problem also. But shifting to the jury selection task force, you spoke about lack of faith in our process. I've recognized that for many years. Part of the problem, I think, is that there's a portion of our society that talks about getting out of jury service. This is how you get out.
Yeah.
But I know as a clerk, I did jury trials, I did courtside trials. Many times the judge and I would go in and talk to the jury. It was always a very rewarding experience. In fact, some juries on long, med mal cases where they're there for a month or so, or a criminal case, they actually have reunions.
Yes, I've heard of this.
Yeah, it is a rewarding experience. So, I think an aspect of that may be the public relations side of this, because I do recognize that everybody has a right to a jury. And, my fear is that a makeup of a jury as we go on will be people that are retired, or just people that are retired or unemployed, because the business sector is given the impression that you should get out of jury service. So I don't know how we pierce that.
Yeah.
I'm certainly in favor of this bill.
Well, I'm going to recruit you for my team. I'll tell you that now, because I think you are speaking a lot of truth there. The people who actually do jury duty love to do jury duty, but they will tell you about the hassles of doing it first. And so what I'm trying to do is look at this in a holistic way and deal with all of that. As far as the education part, I'm being totally honest with you. I am going to call you and ask for your help, because I think that message needs to get out. The other half is what I'm here talking to you folks about, is making those changes that we need to make in order to get people, in order to take care of their needs, to get them into the courthouse.
Great. Thank you. And thank you for your testimony. Nice to see you again.
You too, sir.
Thank you, Representative Fishbein. Good morning, and Representative O'Day, you have the floor.
Thank you, Mr. Chair, and thank you, Chief Justice, very much for your testimony. I will say, Attorney Matt Hirsch and I tried a legal mal case in front of Judge DeAndrea, and we had a jurors reunion a couple times after that trial. And so I echo the comments made by my ranking member. And but my concern is now with COVID, I know we're going to try getting trials back. I assume the commission did not address the impacts of COVID and getting people back. I mean, it was hard enough in the civil cases to get people to serve as jurors. Are you confident that we'll be able to have jury trials back in May, June?
I won't say May, June. I am confident that we will have them soon. The thing we're trying to, do the first thing we're trying to take care of is to make sure that people are safe. Equal to that, I think, is probably, the defendant's rights in these cases, as well as the party's rights. But we can't do this if we can't do it safely. I've been talking to my fellow Chief Justices all around the country, and they've done this in different ways. And some of them have been pretty disastrous. There's one state that had 13 jurors test positive with COVID. We can't have that. That jury duty should not be one of the things where you're putting your life on the line to make the system work. There are better ways. A lot of our infrastructure is older, so that's going to be our problem. We're thinking about ideas of doing juries in the newer buildings with better HVAC systems. Everything is on the table, and we will get it done. It's just that when you have a continuing organization operational plan, you tend to think in terms of days or weeks or months. A pandemic in years isn't the kind of thing that we planned out as well as I wish we had.
And I don't want to take up too much of your time. I just want to just let everybody know that maybe watching this and on the committee, as a trial attorney who spends a lot of time in the Stanford courthouse, it is very difficult in Fairfield County in particular, to get judges because of the decrease in pay you have to take from private practice to becoming a judge, and the cost of living in Stanford. And Your Honor, I know you know it from being down here, how difficult it is. And so while I know people on the committee and maybe watching think that the salary sounds like it's a lot of money, and certainly it is, but it's for living down here with multiple children and loans, obviously going through law school, it's very difficult to attract the best and brightest when you have to take such a significant pay cut to do the job. So I thank you, Mr. Chief Justice, very much for your testimony. We miss you down here, and appreciate the time you've given to us. And thank you, Mr. Chair, very much.
Thank you.
Thank you, Representative. Good morning, Representative Blumenthal. You have the floor.
Thank you, Mr. Chair, and good to see you, Mr. Chief Justice. Thanks for being with us this morning.
Thanks for having me.
I really appreciate your testimony so far, and I wanted to ask you a question or two about the task force. It's kind of a preliminary for my colleagues. I was lucky enough to have the opportunity to serve on the task force, and I have to say, it was a very productive group, characterized by a lot of really important work being done. And I think in the legislature, we're not as used to task forces being so productive. So you may have created a dangerous precedent for yourself. You may be chairing a lot more task forces going forward if you're not careful.
It's a good problem to have.
I want to say, first of all, or ask you, first of all, you talked a bit about kind of the perception of jury service and the perception about whether people are having a jury of their peers when they are in court being tried or trying a case. Would you mind talking a bit more about what motivated you to convene this task force and a bit of the history behind it?
Okay, I'll try to keep this as short as possible. But I have to start back with the Civil War. After the Civil War, Blacks were freed and were given full rights of citizenship. But in the state of West Virginia, there was a case called Straughter versus West Virginia, and there was a state law that said Blacks could not serve on the jury. The United States Supreme Court reversed that decision and fully said Blacks can sit on the jury. If you go forward about 100 years, you end up with Batson, Batson versus Kentucky. And that's a case where the prosecutor struck every Black juror, every prospective Black juror. Mr. Batson was a Black individual. He's entitled to a jury of his peers. That went to the United States Supreme Court. Supreme Court said Straughter is good law, that Blacks have a right to sit on the jury, and it's a constitutional right. However, Batson is basically a toothless tiger. There's stuff now that we know about how the mind works, like implicit bias. So people are being struck because there's a perception that they may be biased towards the defendant, or because of something that happened in their life that they have no control over. For example, policing tends to occur in urban areas. We do know about the problem of driving while Black and those kinds of things. If a person is stopped driving while Black, the prosecutor may say, you can't sit on this case. The problem is that would eliminate me and most of the people that I know, most of the Black men that I know. How in the world can that be fair, that a circumstance totally beyond your control can dominate that constitutional right? So State versus Holmes comes in, and there's this issue concerning a juror who has this rich Black background. And he says right up front, this isn't a case where a judge has to rehabilitate him. He says right up front, I'm afraid that I'm not going to be on this jury because of me, what I do and who I am. But he says, I can be fair. Almost every few minutes, he's saying, I can do this fairly. He was struck because the prosecutor had concerns about who he was as a life experience. And that, once again, that can't be fair. But under Batson, it's constitutional. So I felt I needed to address that. And the case of State versus Holmes, I believe that we sent either a synopsis of that over or the case itself. And that's what really got me inspired to put together this jury task force to find better ways to address this problem.
Really appreciate that explanation and that background. And could you talk a bit more about kind of the dynamic of the task force? Were the proposals that we're seeing today controversial on the task force? Were they widely agreed to by the participants?
Most of them were widely agreed to. I have to tell you how I put this task force together. With a lot of my own thinking, I reached out to various attorneys. The chief court administrator was extremely helpful, the deputy administrator. And we tried to figure out how to get a team together that wasn't an echo chamber. I didn't need a group of people who thought the way I thought. This problem is huge, and I needed people from every walk of life, from the NAACP to prosecutors to defense attorneys to the public defenders to trial lawyers, you name it, and I put them on the jury. And I was really mindful to put people who I thought would not agree with me on this task force. And that's why you had this robust, healthy debate. And I think a lot of good came out of that, but it's not an echo chamber kind of doctrine. It is one of these things that discussion by some of the brightest legal minds in this state had with each other. They fought with each other, they discussed with each other, and they came to these conclusions.
Thank you for that testimony. And I want to thank you again for convening this task force, having served on it. I really appreciated the situation and the dynamic that you created. I think you're very right when you say you convened a diverse array of perspectives and people felt very comfortable sharing the perspectives. But ultimately, the conclusions we came to were almost universal, almost unanimous in almost all cases. So I think that is a testament to both the quality and the diversity of thought that you put on that task force. And I'm, of course, not including myself in that, as I kind of elbowed my way on. But I really, again, appreciate all your work on this. And I guess one comment, I would just encourage the branch as we move forward into doing more trials to think about a universal plan. I know I've heard that that's what's anticipated, but I think that it will make it easier for lawyers and litigants across the state if the plan where we go back to trial is one that is more universal across the state rather than different in different judicial districts. So I would just ask that you consider that. And I would echo the comments of my colleagues about the experience of jury service as a trial lawyer who's tried a number of cases in Connecticut state courts. I've never met a juror who regretted serving on a jury. They universally have really excellent and meaningful experiences. And my cases tend to be longer. So you would think that they would get tired of us, and maybe they got tired of us, but they didn't get tired of each other or the experience. So thank you very much, Mr. Chief Justice, and thank you, Mr. Chair.
Thank you.
Thank you, Representative and Chief Justice. I say you did a great job because you said, I'll try to be as short as possible. And then you said, but I have to start with the Civil War, and I got worried. Good morning, Representative Palm. You have the floor.
Thank you, Mr. Chair. Good morning, Chief Justice. Thank you for being here. I have a couple of quick questions. Well, first of all, thank you for trying to diversify and make it easier for people to be on juries. In your experience, is the low $50 compensation a hindrance? Do a lot of people try to get out of it because of that?
It's a real problem. One of the things that's happening is this economic divide that I'm really worried about, and I'm really worried about it when it comes to we're leveraging technology, and I'm worried about how we may affect people who can't afford to even have wideband. This is a direction I think we're all going to go into, all branches of government, and we need to be very careful what we do that we don't leave groups behind. When it comes to jury duty, missing out a day's pay for most people won't be that much of a problem in their life. Missing out a week's pay is more of a problem. Missing 2 weeks' pay is more of a problem. So you're actually losing people through this process in ways that we really didn't think about that much. I mean, things like, if you want to really get innovative, you can say, maybe we can do childcare. With the current budget situation, we probably can't. But this is one of those things that we can do. We can make sure that people are able to put food on their table and do jury duty. To me, that's a minimum that we should try to guarantee.
Well, thank you for that. Some years back, I was called for jury duty, and just before the voir dire, a bunch of us were sitting around in that small room and talking, and several people said they were sharing tips about how to get out of jury duty. You know, pretend you know this person, or say you're a racist, or say you hate white people. You know, the wrong ways to disqualify yourself. And the primary reason was because of the low pay. And then I remember this so clearly. A Russian immigrant spoke up, and he put us all to shame by saying, "This is why I came to America. Isn't this the point of being an American, to have a jury of your peers? Why are you all trying to get out of this?" He was back.
I wish you could remember his name. I could use him.
And it was very, very moving. But and I'm guessing, this is an assumption, but I'm guessing he probably had fewer financial resources than most of us, and it didn't matter to him. So thank you for that effort. I do appreciate it. And then I have a quick question about the judicial compensation. What are the criteria people express to you other than financial compensation when considering being considered for a judge? I mean, when we apply for a job, we all have to look at a range of factors about why this position would interest us. Other than the compensation problem or factor, what do you hear from people about their motivation for serving on the bench?
The compensation factor is actually the number one factor I think people consider against taking the job. There's others, like it's a pretty monastic life. And if you're a litigator, you love litigation, you sort of have to sever your ties from everybody in that world that you knew for that period of time. But those are kind of tough things that people can consider that there's not much we can do about it. That's part of the job. But this other part, I can tell you, I won't say the name of the judge, but when I was nominated, one of the judges who I practiced in front of gave me a call to congratulate me. And so he invited me to lunch. We went down and spoke. And he says, "You're going to love this job. You're absolutely going to love this job, except you're going to have to get used to not getting the money." And so I looked at him and I said, "I'm a government attorney. It's actually a raise for me." So that actually gets into what I was saying about what the task force needs to look at. You look at not just governmental attorneys' salaries, and it tends to be a raise for them, but you look at the attorneys who are practicing law in general, and it's not a raise, it's a loss for them.
I guess my question wasn't so much what are the criteria that discourage people, but what are the criteria that encourage people, aside from the issue of whether or not there's enough money? Why does somebody want to become a judge?
For me, I love being the traffic cop. I love, by that I mean the GA judge sitting and doing arraignment kind of stuff. I love the busyness and everything else, but I didn't get to concentrate on the law and how it works. I mean, the reason why I went to law school is because of that. When I got to the appellate court, it was even better. When I got to the Supreme Court, it was fantastic. Now that I'm Chief Justice, a lot of my time is on the administrative stuff, so I don't really get to do the things with the law that I love to do. But one of the greatest things about judging is you have people who love doing this, who love thinking about the law. During lunch, we sit there and what do we talk and argue about? The law. It just never leaves us. We absolutely love it. So those are the kind of things that attract you. But however, when you start thinking about, you have kids that you're trying to save for college, you have kids who are in college, those kinds of things. And when the salaries really haven't even kept up with the rate of inflation, you're not just getting a reduced salary. The more you're on the bench, it's getting reduced further and further and further. So you're starting to see people leave. And I won't name the individuals, but I've seen a couple of judges leave who were what I would call young judges. Who had a lot of years before retirement, but they left anyway because they could not make this work economically.
And do you feel as though this bill would address past, you gave a little bit of the history of raises were voted, then rescinded, and in your estimation, does this compensate for that back and forth thing that the legislature did?
It does, but I think what it does more than that is it helps build confidence that you will receive increases in the future. This is a problem we're having structurally with the state, I think, in general, and with judicial employees. People are looking at it, and the excluded employees are looking and saying, "I haven't received a raise in X amount of years." And the judges are saying, "Well, we haven't received a raise in X amount of years. And before my dollar went this far, and now it only goes this far." So if we can sort of give hope that these kinds of things will be more equitable, will be more in consideration of what is going on in the world around us, I think that'll be enough for a lot of us.
Thank you. Thank you very much, Chief Justice. Thanks, Mr. Chair. That's it for me.
Thank you, Representative. Good morning, Representative Gilchrist. You have the floor.
Good morning. Thank you, Mr. Chair, and so nice to see you, Chief Justice.
You too.
My questions too surround the jury selection recommendations. I did have the honor and the privilege of serving on a jury in the Hartford Criminal Court last January, and it was a tremendous experience. having to come to a unanimous decision is far harder than anything we do in this building. So that was just mind blowing. And also to think back that I was in such a little room with that many people in January, right before the pandemic. But what I noticed that came up over and over was that folks were getting out of jury duty because of the childcare. And so I am wondering, in the task force conversations, can you tell us more about those conversations? I'm happy to see childcare included in this proposal. How big of an issue is that in jury selection?
It's a huge issue for the individuals who it affects. I mean, we're talking about, once again, we're talking economically, but not about the people who are living from paycheck to paycheck. I mean, I'm sorry, that's exactly who you're talking about. You're not talking about people who can afford to live without going from paycheck to paycheck. So childcare, back when my children were small, it was extremely expensive and ate up a lot of our income. If we're losing that population, and rightfully so, because if I'm a judge and I'm sitting there and you tell me you have no child care and or you're not making enough money to pay for your child care for that week, then I'm probably going to excuse you because you're more thinking about your children and that bill than you are about the trial that you're supposed to be on. If we can do something to help those folks, if we can do something to make sure that there's more equity in the system, then I think we should do it. We are rapidly suffering from eroding confidence in our system. And that's because too many people are excluded for various reasons that we haven't thought of. 2020 wasn't the interruption that we wanted, but in many ways it's the interruption we needed because we started to become conscious about all these flaws in our system. Some of them, we're gonna have to throw some money at the problems. Other ones, it's just sweat equity. But this entire process will make our judicial system better, and that's what we need to work towards.
So, thank you for that. In your earlier comments, you mentioned childcare. Am I correct that this proposal would offer a childcare stipend if someone serves longer than 5 days?
I don't remember off the top of my head. I'd have to look at the report.
Do you think it would be best? Do you think you'd be able to get more folks to serve on the jury if childcare was something that was offered from day one, some type of stipend?
I do. But you got to remember, you folks do the hearings and things like that. You have connection with the public better than I do. When I was doing my testimony earlier, that is one of the other things you miss becoming a judge. You sort of lose that connection with the public. Thankfully, I have folks like you to listen to them and to come in and testify, and you will be able to educate me on exactly how we should do this. I'm trying to get you in the ballpark, but to go over, I'm about to mix my analogies, mix my metaphors. To get over the goal line, I need your help.
Well, happy to help. Thank you so much. Thank you, Mr. Chair.
Thank you, Representative. Good morning, Representative Callahan, you have the floor.
Thank you, Mr. Chairman. Good morning, Chief Justice Robinson. Great to see you.
Yes, sir.
I know how difficult it is for the Chief Justice to go from the trial judges to that big building on Capitol Ave, and I know it's tremendous pressure on you, so I appreciate you taking the job and being here and doing such a great job leading the Connecticut's judicial branch.
Thank you.
As you know, I have had the opportunity to serve in front of, with and in front of numerous judges in Connecticut, and there are many, many talented judges in Connecticut that take the job. So far we've been getting some great talent. What is I forget though, what is, how many years before the judges in Connecticut are eligible for a pension?
That's changed a number of different times. I'm trying to remember exactly what it is now. With my class of judges, it was 10 years of service and age 63, I think it was. In order to vest, 10 years of service in order to vest, and you could retire at age 63. Now it's different. I was talking to one of the newer trial judges, and he was telling me how long he had to stay, and it's considerably longer amount of time and more contributions up front.
Thank you, Your Honor. And I know our committee has several judges. Potential judges will be interviewing on Wednesday, and we look forward to that. And that's my only question this morning. It's great to see you, Your Honor, and thank you, Mr. Chairman.
Thank you, sir.
Thank you, Representative. Good morning, and you have the floor, Representative Quinn. You're on mute. You need to unmute yourself.
I hit the lower the hand and not the unmute. Thank you, Mr. Chairman, and good morning, Chief Justice. I served on the 2012-2016 Judicial Compensation Commission, and we had made a number of recommendations. What is the current salary of a Superior Court judge? You may have mentioned that earlier, but I think I missed it.
I wish that Pat Carroll was here to help me out with this. I believe it's about 186, but I could be wrong about that.
Okay. And when was the last time they were given a raise?
The last raise was effective, I believe it was 2017, but it went to the 2015 numbers that you gave us.
Okay. In looking back at my chart, we had judges making $180,460 in fiscal year 17, and I don't know that they got to that level in 17, but it sounds like they may have actually gone higher.
That may not be the case. Please don't hold me to that.
Okay. All right. Are we seeing a decrease in the number of people submitting their names to be considered to be a judge?
As far as I know, no, we're not seeing a decrease. The question is, though, it's like any other profession. Who are you attracting to the positions? If you're not attracting the best candidates because they feel that there is this economic barrier, then I think you need to do something about that. I think we need to do something about that. When I think of the superstars that we've gotten from the civil side who were from either medium or large firms, who left those firms when they were relatively young in their career-wise, in other words, not 65, which is the age of retirement for some firms. It was a tremendous asset to the branch. A lot of those people, when I've talked to them, though, said this was a very difficult decision because of the economic factor. So it is making a difference. And sometimes it makes a huge difference. When I've talked to some of the judges who have left, the bench, and we talked about that, well, why did you leave? And it was the economic factor. I could not do this based on the salary that I was getting. That hurt. The one I'm thinking about in particular, the last one I talked to, he was an incredible judge, very well loved in a difficult assignment. And I wish I can get him back. I'm hoping one day, while I'm still chief, that it does work out for him and he comes back.
Okay, and if I'm reading what's proposed in 988 correctly, for the current fiscal year would get a Superior Court judge up to 184 and 60, and then what they proposed for the subsequent years was, rather than set a number, which is what we did on our commission, that it be tied to the consumer price index?
Yes.
Okay.
That is correct.
All right. I have no further questions. Thank you very much, Chief Justice.
Thank you.
Thank you very much, Representative. Are there other comments or questions from members of the committee? Representative Rabimbis, good morning. You have the floor.
Yes, good morning, Mr. Chairman, and good morning, Justice. How are you?
I'm well. Yourself?
Good. I just had a few quick questions, if you wouldn't mind. On your task force, did you guys discuss comparing, I guess, the state of Connecticut to other states as to how judges are nominated to the bench? I mean, how many other states actually have the process of going through a governor for nomination, if you know?
The task force didn't discuss that, but I've been all over the country in the last 2 years doing a lot of implicit bias training, believe it or not. And I find that most of the judiciaries now are elected judiciaries. And we've debated about that. There's some unique problems with it. There's some unique advantages to it. But I've never had the conversation with them about tying pay to the nomination process. So I don't know that I can see if I can find that kind of data for you rather quickly.
Okay, and I was certainly inquiring only because of the recruitment process. Do you know how many people might be on the judicial selection list?
No, I do not at this point.
Okay, and probably, and I don't want to assume, but I'll give you the opportunity. Do you know what the breakdown of diversity of those individuals may be, either based on race, sex, and or age?
Off top, I can get the information for you. Off the top of my head, I don't know it, but I do know that there is a significant problem of trying to recruit, we've been trying to recruit, but getting people to even accept the idea of coming over. You have people who, quite frankly, have a lot of student loans, a lot of debt that they're trying to work through, starting new families, those kinds of things. And that's what we talk about. But I would say there's not a week that goes by where I don't reach out to individuals who I think are qualified for the bench, whether they're people of color or not people of color. I'm just trying to get folks interested in coming in to be judges. And that is a big part of the conversation.
Okay. And I certainly appreciate your testimony here today. And I think, every good judge should be doing exactly that. I mean, they have an opportunity, a unique opportunity to see attorneys who practice in front of them, and see, certain qualities that they would think that would serve best on the bench. My other concern is, those individuals on the judicial selection list that may equally be just as qualified, and unfortunately are not being given the opportunity because we do have the nomination. I mean, one of the things I hear all the time is, well, I would certainly consider being a judge, but I don't have the connections to do so. I don't know Governor X or whoever it may be in that position. I don't know if I would have the support to do so. So I think that there really should be kind of a holistic, probably study, for lack of a better term, of looking at all those, items as well, opposed to, simply, I think it's certainly the salary could be a factor. I don't know if it's a sole factor. The other things, unfortunately, that I've even encountered when I was doing jury selection as well is, certainly the child care is a huge factor. But many of the people who were caring for their children, whether it was the father, mother, or even the guardian that was being selected for jury selection, is not the unknown period of time that they would have to serve on the jury. If they knew it was a day or two, they would probably feel comfortable leaving their children with someone. But anything longer than that, the unknown. So I certainly know that that's one of the other big challenges in that regard. And I'm not exactly sure we could ever address that one, not knowing how long the trials are going to be.
One of the things that happens is the judge and the attorneys tend to know pretty much how long the trial will be. So whenever I did the jury indoctrination, I would go out there and talk to them and say, the trials we have are expected to last, and whatever the group were, whether it's 1 week, 3 weeks, 6 months. And so I'd say, let us know what your commitments are and things like that. So we'll try to slot you in for the right trial. So some of the things we can do are actually pretty easy. It's low hanging fruit. We just need to get better at doing it.
Yeah, which would be, certainly excellent if that guesstimate would actually be held to, or, I can't imagine too many people would want to sign on to something that they know that's going to be months in the calling as well. Unfortunately, knowing that a lot of the uncertainty that may occur even with childcare in that regard. But thank you, Chief Justice, for being here and for testifying.
Thank you.
Thank you, Mr. Chairman.
Thank you, Representative Bimbis. Are there comments or questions from other members of the committee? Comments or questions? I do not see any. So Chief Justice Robinson, thank you for joining us today.
Thank you for having me.
Enjoy the rest of your day. Next, we have Natasha Pierre, followed by Judge Beverly Strike-Kafalis. Ms. Pierre, you have your 3 minutes. You may begin.
Okay. Thank you, Senator Wilfield and members of the committee. I am testifying in support of House Bill 6505, Section 29. Crime victims in Connecticut have state constitutional rights, including the right to be reasonably protected from the accused, to notification, to attend all the proceedings that the defendant is entitled to attend, and to communicate with the prosecution and other things. Public Act 187 requires that any case of a juvenile transfer to the adult criminal docket be private and confidential. At the time it was proposed, the OVA sounded the alarm that the proposal was a complete violation of the constitutional rights of crime victims. Nevertheless, the proposal was passed. It wasn't long after its inception that a crime victim was denied access to court proceedings in the case of a juvenile offender transferred to adult court who was facing charges for killing their mother. The victim was also denied access to any information about the case or the offender and was denied the opportunity to speak with the prosecutor. Further, because there was much confusion around this, the victims were not allowed to see their parents' body until it was already prepped by the funeral home. They did not find out their mother's cause of death until 6 months after she had been buried. We helped that person get into court. They did get into court. That process has ended for them. However, for any future victim, unless they get in touch with a lawyer, they will not be allowed in court. I would like to note that not one defense counsel, and we were dealing with murder and sexual assault cases, not one defense counsel objected to letting the victim in the room. So the bill before you would restore their constitutional rights to be in the room and to get all the information they're entitled to. However, inherent in this bill is that they tied it to the juvenile requirements for what types of information you can release in confidentiality. We oppose that. This requirement is for crime victims with juvenile cases, not adult cases. And we should not be putting the same standard of confidentiality on victims and changing their existing rights. And thank you for your support. Thank you for allowing me to testify on this issue.
Thank you, Ms. Pierre. Representative Fishbein.
Thank you, Mr. Chairman. Good morning, Natasha. Nice to see you.
Good morning.
Understanding that you've been testifying as to Section 29, did you have any comment with regard to Section 54, which also has, it seems to be some protections for victims? Are you aware of that?
Section 54, was that, I'm not sure about that section. It didn't highlight for us. I know there has been some language in other bills about making sure they gather victim information, making sure they assess victims, how victims will be involved in the process. And just as a blanket thing, we've been saying we don't have to recreate a process. We have a process. Just adhere to the existing law. But that particular section I'll look up. We didn't, it was a huge bill, so we might have missed it.
Yes, very huge. There should be a bill against huge bills, right? So
Section 54, I'll get to that and get back to you.
Yeah, I'm just going to read to you the change because I don't know if you've discussed in the office. What this has to do, it says any victim of a crime, and this begins, I like it when people use line numbers, so I'll do the same. Line 3,439. Any victim of a crime, any member of the immediate family of such victim is the added language. And it has to do with when an inmate makes an application for the Board of Pardons and Paroles.
So for that particular thing, they're basically trying to fix their statute to adhere to the current definition of crime victim, which is their family members as well, especially if it's a murder.
Understood. Well, I don't know that it confines, this language is confined to murder. It appears that it would apply to any inmate, and that's what I wanted to.
Okay, so the question is the family, who's the family member, the victim's family member or the inmate?
It's the victim. It says any member of the immediate family of such victim. So
that's existing law. So parole must be trying to tweak something to make sure they're adhering to what they're supposed to be doing already. So I'll have to look at that to really figure out what the issue might be.
Okay, the language that they're adding when you say it's existing law, the underlined portion of this bill says that they're adding to the existing law the clause any member of the immediate family of such victim. So when you say
what I'm saying to you is the current definition in 1.1 is that. So if they're fixing it, it's because they didn't include that in their definitions and it should have been in there.
Okay, yeah, if you could take a look at that, my concern, just so that you know, is is this only people that are inmates? Because it's the application of an inmate. It's not an application of a former inmate.
Okay, I'll have to
So
look at that.
somebody's been incarcerated, they've been let out, they're in the community, they apply for a pardon. Do they fall within this language? That's a concern.
Mhm.
Okay. And how far does immediate family go? Because as part of the pardon process, the applicant has to let any victim give notice to victims, right?
Mhm.
So, potentially that could be utilized as a tool to make it very oppressive for someone to apply for a pardon.
Mhm.
Somebody's got 10 children, they all apply, and now this person who's applying for pardon's got to go find 10 children to give them all notice. Those
Okay.
are all concerns to me. So I look forward to, you looking at that and perhaps getting back to us. So thank you, and thank you, Mr. Chairman.
Thank you, Representative. Are there comments or questions from other members of the committee? Comments or questions? I do not see any. Representative Paul.
Thank you, Mr. Chair. Sorry about the late hand raise. Hi, Natasha. It's so good to see you.
Hi, Christine.
I read your testimony, and I just want to make sure I'm understanding that, in essence, you're saying that when a crime is committed by a juvenile, you're in favor of keeping those records essentially closed to protect the juvenile, but then when it gets transferred to an adult court, the victim's family has the right to then see it. Am I reading that testimony correctly?
Okay, yeah, I mean, the victims have the right in all systems to get information. It's just in juvenile system, they can't, the information is limited, it's less information. So like, and if this case had been in juvenile court, they would have been able to find out the cause of death of their mom. They would have been able to be involved in the transport of their mom to so all those things would have happened whether they were in an adult court or juvenile court. The difference is how much you can share. Well, one, you don't get as much information in juvenile. Like you have to, if you can, in adult courses, you can get anything that's in the file for the most part. Mm-hmm. For juvenile, you get basic information, a little bit of information, and then you'd have to file a motion to get more information. Okay, so that's the only difference. But by putting the adult case, the juvenile to adult cases into adult court, they're limiting their information, period. And frankly, at the time that this happened, it happened so quickly, the courts and the police, everybody just wasn't sharing anything because they had to write policies and procedures about what information they could share. So it's different kinds of information. The other thing is different kinds of restitution in the different courts too.
And so you're saying that was sort of an unintended consequence of the Public Act 19187?
I don't know if it was unintended. They completely excluded the whole population out of the group. So
okay, and that was the inherent
but
flaw.
now that they're being allowed back in, or this proposal would allow them back in, but it would still make them play by the juvenile court rules when they're in adult court.
Gotcha. Okay. All right. Thank you for clarifying that. Thank you, Mr. Chair.
Thank you, Representative. Are there comments or questions from other members of the committee? Comments or questions? I do not see any. Ms. Pierre, thank you for joining us this morning.
Thank you for having me. Have a great day.
You too. We will next hear from Judge Beverly Strike-Kafalis, followed by Christine Rapillo. Is Judge Strike-Kafalis in? Yes, you are. You have 3 minutes.
Good morning, Senator Winfield, Representative Staffstrom, Senator Kissel, I'm not sure is on the meeting at the moment, Representative Fishbein, and members of the Judiciary Committee. I have submitted written testimony on 3 bills before the committee this morning. Raise Bill 940, an act concerning state agency compliance with probate court orders. House Bill 6505, which is the Judicial Branches Act concerning court operations, and Raise Bill 959, the Act concerning probate court operations. Just to quickly highlight points in my written testimony, I am testifying in support of Senate Bill 940, which confirms existing case law regarding state agencies' requirement to be bound by a court's decision And if they are aggrieved, just like any other party, they do have the right to appeal such a decision to the Superior Court. Raise Bill 6505, in particular, Section 15, addresses a new procedure, which was a collaboration between my office and the judicial branch to change the approval process for the approval of the Connecticut probate rules of procedure, which again, I support. And finally, I'm here this morning in support of Raise Bill 959, an act concerning probate court operations. The bill proposes a number of changes to ensure consistency in terminology, incorporates changes consistent with the Connecticut Uniform Trust Code, which was enacted in 2019. It also proposes waiver of probate fees for state agencies when the state agency is responsible for certain indigent expenses. Those requests were made by those state agencies, as well as a waiver of fees for adoptions involving children with special needs. There's an additional proposal to include guardians of adults with intellectual disability when they are granted limited financial authority, that they would also have the authority to settle final expenses after the death of such individual, which is consistent with similar provisions for other fiduciaries, such as a guardian of an estate or a conservator of an estate. There are some other provisions in the act. I'd be happy to answer any specific questions. But in general, I'm here in support of the entirety of that proposed legislation. Thank you.
Thank you. Representative Fishbein.
Thank you, Mr. Chairman. Good morning, Judge. Nice to see you again.
Good morning.
I'm intrigued by Raise Bill 940 and the need for it. Presently a matter in probate court comes before the judge as two parties. And let's say on one side, the dispute on one side is the state, and the other side is the executor of the estate. And you make a determination, or the judge makes a determination that's adverse in the opinion of the executor. They fall within the current appeal process, correct? They would be able to bring an action under the current statute.
Right. Any party aggrieved by a probate court order has the right to file an appeal with the Superior Court.
Okay, well, it appears that this language of 940 now says that the state, which is on the other side of that case, would now have that ability also. And am I reading that correctly?
Well, the state agency, I'm just trying to get my fingertips on the bill language itself. It's not a bill that we have expressly proposed. I'm testifying in support of it. But a state agency currently does have the right to appeal if it's an aggrieved party to a decision. My understanding is that there have been certain probate court decisions that state agencies have disagreed with, but have failed to adhere to the terms of the court decision, particularly in certain conservatorship proceedings when it came to assets or income expenses. There is a particular Supreme Court decision of the Connecticut Supreme Court, Valieri, that really goes through that case law, and this proposed bill clarifies and confirms that the state agencies are similarly bound by a final decision, just like any other party, and if they are aggrieved, should appeal it. But that is not always historically what has occurred.
So presently, when a probate court judge makes a determination and the state fails to abide by that and doesn't appeal, is there a process by which, usually a judge can hold a party in contempt? Is there a process by which the commissioner of that department is potentially held in contempt, or what do you do?
Well, I suppose it would depend on how the issue is brought before the court. Certainly, if a party files a motion for contempt, the court could adjudicate that. But that would be distinct, really, from the failure to abide by a final decision. And it really, what the bill just proposes is consistency with what current law provides.
Yeah, I'm just a little, I mean, if a party is not abiding by a court order, this appears to say to state agencies, you have to file, or you have the ability to file an appeal. And it gets to the question, well, what if they don't? And what if they fail to abide? Is there remedy?
Well, current law would be the contempt proceeding. What this does is codify that it actually, they are bound by it. So it's a statutory compliance as well.
Okay, thank you. As I said, I'm intrigued. So thank you, Mr. Chairman.
Thank you.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? I do not see any. I want to thank you, Judge, for joining us this morning, and I hope you have a great day.
Thank you. Have a great day, everyone.
Next, we'll hear from the Chief Public Defender, Christine Rapillo, followed by Tanya Hugh, the Executive Director of the Commission on Human Rights and Opportunities. Christine Rapillo.
Thank you, Senator Winfield. Good morning, members of the Judiciary Committee. I'm here today to testify in support of Bill 6548, an act concerning the recommendations of the Jury Task Force. I also was lucky enough to sit as a member of this task force, and as echoing Representative Blumenthal, really just found it to be one of the more inspiring and rewarding things that I've done since becoming Chief Public Defender. I think, as everybody can agree, the right to a trial by jury of one's peers is a fundamental bedrock of our whole justice system, not just the criminal justice system. And it's critical that we make jury service accessible to everybody. Making sure that people are able to serve on juries will make them more willing to serve on juries. And in order to do that, we need to make it better for people. We need to pay people, we need to expand the jury pool, and the recommendations in 6548 will do that. This will getting more people into the door, getting more people willing to serve, will improve the diversity of our jury pools, which will in turn increase the confidence in the system, both of the people using the system, in our case, the indigent criminal accused that we represent, but also of everybody who participates in the system, because they'll feel like they're part of it. I submitted written testimony. I won't read that testimony, but I would urge the committee to act favorably on these recommendations, and I'm happy to answer any questions.
Thank you, Attorney Rapillo. Good morning, Representative Howard. You have the floor.
Good morning, Mr. Chairman. Thank you, sir. Good morning, Ms. Rapillo. How are you?
I'm fine, Representative. Nice to see you again.
Nice to see you as well. Two quick questions. One, on the task force, I noticed that we kept the age of 18. And there's been significant discussion, as you well know, statewide about brain development and ability to make decisions. And certainly jurors make, I guess not in Connecticut, but almost life and death decisions, as far as people could be sentenced to life. Was there discussion on the task force about perhaps moving that age up to a more mature level?
Not in the discussion. I sat on the Batson task force and then obviously participated in the full meeting. So no, I didn't. I'm not aware of any discussion about changing the age, the minimum age for jury service.
Thank you for that. And the other quick question is, we both work in the criminal justice system. I think we both know that a lot of folks, rather than take responsibility for their own actions, will blame a system that's been more than fair to them. They will blame their public defender, they'll blame the prosecutor, the judge, the police officer, the guy sweeping the floor, anybody they can. Some folks have expressed concern to me by way of email, their concern over convicted felons being able to serve on juries and perhaps grinding an axe. In your experience with those types of defendants, do you feel that the voir dire process will probably pretty much take care of that?
I think the voir dire process would take care of that. You'll notice that from the recommendations, there was not a recommendation that we do away with peremptory challenges. So, not only could people be excused for cause pursuant to a ruling for the judge, but both sides of any case would have the ability to remove a juror from the pool using a peremptory challenge. So I think that's sufficient to protect everybody who participates in the system.
So basically, just for those non-lawyers like myself, so to understand it is if either side says, hey, this person is here for the wrong reasons, they're not able to be fair because of their past history, that person can be eliminated and won't be on that jury.
That's right. A peremptory is where you can excuse somebody without giving a reason. Just the reason has to not be a discriminatory reason. So again, what we're trying to address here is diversity on jury pools.
Right.
You can't excuse somebody just because of their gender, their race, or some other factor like that. But it does give lawyers an ability to remove somebody from the pool for reasons that would concern that they couldn't be fair to their case.
Sure. Thank you for those answers. I appreciate you being here, and I appreciate you taking my questions. Thank you, Mr. Chairman.
Thank you, Representative Howard. Representative Blumenthal.
Thank you, Mr. Chair. Nice to see you, Madam Chief Public Defender.
Nice to see you too.
I just wanted to thank you again for all your contributions to the task force and for being with us today and answering questions. I don't really have any questions myself. I just wanted to make my appreciation known, and I know that the committee feels similarly.
It was a terrific experience. Thank you.
Thank you, Representative Blumenthal. Comment or questions from members of the committee? Comment or questions? I do not see any. Attorney Rapillo, thank you for joining us again. I hope you have a wonderful day.
Thank you. You too.
Next, we'll hear from Tanya Hughes, followed by Cheryl Sharp, or I don't know if they're together, Chris Drake, and Chase Rogers. Is Tanya Hughes in?
Good morning.
Good
Yes,
morning.
Senator. Good morning, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and members of the Judiciary Committee. Thank you for the opportunity to testify on Senate Bill 1023, an act concerning the duties and responsibilities of the Commission on Human Rights and Opportunities. I'm Tanya Hughes, the Executive Director, and with me is Deputy Director Sharp, and will be available for questions following my testimony. We appreciate the Judiciary Committee raising Senate Bill 1023, which aims to streamline and update several of the Commission's processes and statutory provisions. Our submitted written testimony goes into detail regarding each section of the bill, so I'll limit my remarks to a few key aspects of SB 1023 before making ourselves available for questions. First, as you know, the Time's Up Bill of 2019 established new sexual harassment training requirements for employers in Connecticut. Section 7 of the bill deals with an issue arising from these new requirements by allowing CHRO sexual harassment training to be portable for 2 years. We've heard from various employers and employees that they do not want to have to redo training that they recently completed at another job. We know that many members of the committee have also heard from their constituents about this issue. Under current law, an employee who had several jobs might have had to take the training multiple times within a short period. That's not what the law intended. This section allows people who have taken the CHRO training to utilize that at any subsequent job for the following 2 years, making the training requirements easier to satisfy for both employees and employers. Another important piece of the bill is sections 1 and 2, which extend the prohibitions against both retaliation for opposing discrimination and aiding and abetting discrimination under current law to apply to public accommodations. For example, a restaurant should not be permitted to refuse service to a customer because they previously filed a CHRO complaint, just as under current law, an employer is not permitted to retaliate against an employee for doing so. Section 2 also aims to cover situations in both employment and public accommodations when an adverse action is taken against someone directly because of a third person's opposition to discrimination. There is public policy interest in protecting the right to oppose discrimination. We've seen cases such as an employer who terminates an employee because their spouse opposed discrimination, a hospital that refuses treatment to a child because the child's parent opposed discrimination, or an employer who refused to hire an employee because of the employee's relationship with a former employee who opposed discrimination. These types of situations do not fit squarely within the current law, and makes it very difficult to pursue. The language in Section 2 will prohibit this type of retaliation. We continue to work with LCO to make sure that the language in this section covers these types of situations while also requiring that the complainant proves that the alleged retaliatory action against them was because of the third person's opposition to a discriminatory practice. So we thank the committee for raising the bill, and both Cheryl and I are happy to answer any questions you may have at this time.
Thank you. Is there a comment or question from members of the committee? Comment or question? Representative O'Day, good morning. You have the floor.
Thank you very much, Mr. Chair, and thank you, Commissioner Hughes, for your testimony. Just a quick question on Section 2, lines 145. Is that where the restaurant aspect is? It shall be a discriminatory practice in violation of the section for any person to discriminate against any other person because of such other person's opposition to any discriminatory practice, or because such other person has filed a complaint or testified or assisted in a proceeding under the section. Is that the reference to the restaurant?
Correct. Well, no, that's the reference to the third party opposition.
I guess my concern is if somebody testifies against a person for discriminatory practice, and that the respondent believes they are testifying inaccurately, either intentionally or not, lying to the commission, in essence, they can't prevent that person from, let's say I run a restaurant and somebody files a complaint against my restaurant that I believe is baseless, and they testified in a way that does not accurately reflect what my understanding of the facts were. If that person comes into my restaurant, I have to serve them. I can't refuse to serve them for what I believe to be a false claim against me.
That would be correct, sir.
And what? So,
because people have the right to complain and to file a complaint. I understand your point about it not being a legitimate complaint, and there are other forms of redress for that, but they do have the right to complain if they feel that it's a legitimate complaint.
So if I want to, what's my redress if I want to, if somebody is falsely accusing me of discriminatory practice as a restaurateur, how can I choose not to serve them going forward? What's the other redress I would have?
I'm going to ask Attorney Sharp to answer that question for you.
That's a good morning. I'm Cheryl Sharp, the Deputy Director at the Commission on Human Rights and Opportunities. That's a difficult question. I understand where you're going with the question. It's one of the costs of doing business that we accept and receive complaints of discrimination, and individuals should not be retaliated against because they oppose discriminatory conduct. And the way that the law is written, it's that the protection is for the opposition to discrimination, because it was so prevalent, the discrimination that was occurring over decades, that the law was presumably written by the legislature in that way to protect individuals who wanted to oppose discriminatory conduct and not be retaliated against after that opposition. Complaints are filed with the commission where we don't find reasonable cause to believe discrimination occurred, but it doesn't take away that person's right to have filed the complaint. Normally, companies have policies where if an individual provides testimony that was false, that there is a policy within the company that allows them to take an action against an employee if that occurs. Restaurants can have policies related to conduct, but it's normally criminal activity or conduct to not allow people to come into their doors. Opposing discrimination, or what you believe to be discrimination, wouldn't be deemed to be criminal conduct. So that's what the state of the law would be.
So if I run a restaurant and I believe somebody is harassing me, making false claims against me at CHRO and weaponizing it, which was one of my concerns with the legislation that was passed, my redress is not through the CHRO, but rather through the police, or like filing a protective order type? Is that what you're saying?
If what you're deeming them to be engaged in is illegal criminal harassment, yes, then that could be a step that would be taken. So there's public policy reasons for having the law structured in the way that it has been structured as it relates to discrimination. And those public policy reasons are that we have a compelling governmental interest in ending discrimination in our state. And so in order to do that, we afford certain protections. And one of those protections right now in employment is to say you cannot retaliate against an individual because they opposed discriminatory conduct or participated in a discriminatory practices proceeding. The extension of this statute to places of public accommodation is necessary because in places of public accommodation, and we have many of them, right? Hospitals, restaurants, schools, stores, parks, any place where the public is gathered, the law needs to protect individuals who either are participating in a discriminatory practices proceeding or who have opposed discriminatory conduct. Those individuals shouldn't be barred from places because of their opposition to conduct that they believe to be discriminatory. Obviously, no one wants to get a complaint filed against them. Restaurants or any other type of business don't want to have a complaint filed against them, but individuals do have the right to complain about what they believe to be a discriminatory practice. And and I'm saying we loosely, meaning the legislature has decided that this is a compelling governmental interest to ensure that individuals are protected in employment from discrimination when they oppose it or when they participate in the discriminatory practices proceeding. And what this language that is proposed here does is extends that same protection to individuals in places where you are invited as a member of the public to attend. It's to ensure that there's that you can go about your day living free of discrimination ultimately.
And if I could add, Representative O'Day, we do take great pains to assist individuals with filing their complaints. And so we have no interest in taking complaints that have no merit. Our intake officers work very carefully at drafting complaints that are valid and legitimate. And so we have very few opportunities where people would be able to weaponize CHRO and use us to harass people. We work hard at avoiding that. It is of no interest to us to allow that.
And we have also the case assessment review, which is an early summary process review where the case can be dismissed summarily if it's frivolous on its face or fails to state a claim for which relief can be granted. So the legislature actually passed that law to ensure that there would be some summary process available so that complaints of that nature would be dismissed very quickly and swiftly disposed of.
What percent of the claims are dismissed outright at that initial investigation phase?
It ranges, but it has been up to 18%. It ranges between 5 and 18% for the case assessment review. Our housing complaints are not subject to the case assessment review.
And we get probably many, many more inquiries than complaints filed. If out of the thousands of complaints that are filed, we get tens of thousands of inquiries. And so we're able to flush out the non-meritorious, complaints before they become an actual affidavit.
I used to represent a lot of dealerships, and I will say I had a representative dealership where a employee physically assaulted a supervisor, and the initial case assessment was pretty clear the case should have been dismissed, but I was asked by the investigator to offer $2,500 to avoid a release of jurisdiction letter, and that was going to be asked of before a decision. So I understand, look, there are certain there are many cases that are legitimate, and I'm not saying that I'm not trying to take away from those, but there's also a number of cases that are not. And I'm just concerned this section 2, I mean, if I'm a restaurant or a store where I've got somebody who's trying to harass my store, I you know, this just seems like there are issues where our police are going to have to get involved. But I appreciate what you're looking to do, and obviously somebody who has a valid claim should not be discriminated against because of bringing a claim. But I just have some serious concerns about this new section. But I greatly appreciate your responses and your work for the state and our residents. Thank you both very much. Thank you, Mr. Chair.
you.
Thank you, Representative. Representative Gilchrist, you have the floor.
Thank you, Mr. Chair. Hello, Director Hughes. Thank you for your testimony. My question has to do with the portability of the sexual harassment training. I was a big supporter and still am of the Time's Up bill, and did have the experience. I work on 2 separate campuses and work for the legislature. And so I had to take 3 sexual harassment trainings, which I didn't complain about because I was a supporter of the bill, but it was a bit much. How will one make that portable? What will they have to submit? How will that process work?
I think it's up to the individual employer to make those requirements known, but we do have the certificate that is provided at the end of the training upon request. And so that could be used to satisfy that, but different employers can have different parameters of satisfaction in place. Cheryl, you wanted to add?
Yeah, so the portability process is that once you've taken the training and answered all of the questions and received the certificate, you now are trained with respect to the sexual harassment laws. That's if you take the CHRO training. So you're required to take the training that we produced during the Time's Up bill. We were given a couple months and we put the training together. Right now, close to 500,000 people in the state have taken that training. And so you now will receive the certificate, and people get one now. And then when you go to your next employer and they say, well, we have the sexual harassment training, you're required to take it. You now take your certificate, it's portable, and you can show that you've had the training within the past 2 years, because the conundrum has been for the construction industry, it can be that you said you took it 3 times. Sometimes they may have had to take it like 5 times, and they're like, we did this training already. So we just wanted to make it so that the intent of the legislature was certainly met, in that people are receiving the training, but not, the intent was not to have people be trained over and over and over and over and over and over again in such a short period of time.
Yes, fully understand. Thank you so much.
Okay.
Thank you, Representative. Representative Fishbein, you have the floor.
Thank you, Mr. Chairman. Good morning. I just
Good
want
morning.
to take us back to Representative O'Day was asking about. I think you indicated that Section 2 was not the restaurant section of the language. So could you identify what portion of Section 1 you're relying upon in making the representation as to the legal basis for that? Sorry.
Could you give us 1 second?
Are you referring to what would now extend the law to cover places of public accommodation?
I believe the scenario that Commissioner Hughes had given was the restaurateur who wanted to deny someone access, and that was based upon the prior filing of a complaint. And Commissioner Hughes represented that Section 2 was not that language. So I'm trying to find where that language is.
Okay. Thanks for the clarification.
No
I have to open up the
full bill.
The full bill. Sorry, technology is moving slowly here. I'm trying to get this other computer to, to open up.
Yeah,
So-
unless section 2 is, I mean, I just.
Yeah, it is
It
section
could,
2.
it is, I just,
Yeah.
Okay.
Lines 145. What we're
Okay,
trying to,
so now that we've identified, because we're all on the same page, that it is section 2
yes,
that's at issue here. Let me give you the following scenario. If somebody goes to a restaurant and they refuse to wear a face mask and they're denied access, and the individual files a complaint with your office claiming that it's based upon their race, creed, sex, whatever, that gender, that they're denied access, and that complaint is pending, and the individual goes back to the restaurant and it attempts to gain access to the restaurant, once again not wearing their face mask. Are you saying that the restaurateur has to allow access? Otherwise,
no.
okay.
If they're not wearing their face masks. What we said is if they're obeying the law, if they're not doing anything in terms of their conduct that's in violation, then yes, the restaurateur would have to allow them access.
Okay, but the lack of access in the second scenario is based upon the restaurateur, their feelings about the initial complaint. That would be barred under section 2.
I thought your scenario was based on the face mask.
Okay, well, let's say in this second section, the second scenario, there's a fear that the individual is going to take off their face mask once they enter the establishment. I mean, based upon the initial filing of the complaint, the restaurateur would have to allow access to that individual. Otherwise, it's a separate allegation to your agency.
it would be a separate allegation to the CHRO saying that because they opposed discrimination previously, that now they're not being allowed to go into the restaurant or eat at the restaurant. It would be a second allegation that they could make. It doesn't mean that they're going to win the first case or the second case, because in the first case, when they came to the restaurant and they said, if the scenario is that, you know, I have a disability and I can't wear this face mask and I'm asking for you to accommodate my disability. And so instead I'm going to wear a face covering with, you know, those plastic, I don't know what you call them, things that people tie around their heads, a face shield instead. And so they are speaking with you, trying to say there's this alternative thing that I can do so that I will be able to eat. Because when people actually start eating, they have to take the face mask off anyway, the face covering, right? They pull it down so that they can eat, or they lift it up so that they can eat. And the person says, well, I have a face shield. And then the restaurateur is like, well, you know, no, we don't allow face shields. Well, then that would be a part of the initial complaint that, you know, I offered some alternative means to comply with the restaurant policy, because that's what I'm assuming you're referring to, is that the restaurant has a policy that everyone has to wear a face covering. It shouldn't be so specific that you have to wear a face mask. If it's a face covering, then that face shield may suffice, especially in light of the fact that restaurants are social distancing and putting the tables or having people sat more than 6 feet apart, and the person is going to wear the face shield. So we take these cases on a case-by-case basis, because given that scenario, then the restaurateur probably is going to be exposing him or herself to liability, because there's this interactive process involved here, right? And that the customer is saying, look, I have this alternative means, and the restaurateur is like, no, you have to wear the face mask or nothing. And then the person comes back to the restaurant a second time, and then the second time it's like, I have my face shield again. this is my favorite restaurant. I really like to eat here. I want to use this. And then they're told, no, you can't come in again. Then yes, they have a second claim, because their claim is going to be, look, I opposed discrimination the first time. I said I could wear the face shield. They didn't allow me to do that. Now I'm here again. They won't let me, wear the face shield, because these are these are real cases, and cases that can occur in schools as well, where kids are sent home because they wear a face shield because they have they could be autistic, or they could have some other disability that does not allow for the mask, which is restricting to them, or they have some other mental health condition that does not allow them to have something covering their face like this, but they could wear the face shield. So they're still protecting others around them. This is what we're trying to address. They're protecting others because they're making it so that their spittle does not get on other people, but they're also protecting themselves in that they have a disability that needs to be accommodated. So,
and Representative Fishbein, the complainant would have to show that they were being barred from the restaurant because of their prior opposition.
How long does that take?
Depends on the length of the case. Generally, they can be resolved as soon as 90 days or as long as a year, you know.
Yeah. And sometimes we have pre-answer, conciliation, and it's done before we even get an answer. And so the complaint is served, and it could be done in 30 days if the respondent's like, you know what, I thought more about it, and I'm going to let them come to the restaurant now. And then the complainant's like, oh, okay, cool, because that's my favorite restaurant and that's where I want to go. So these are just real, putting into law solutions to practical problems that people are facing, throughout the state. Just really trying to do normal everyday things that the rest of us get to do, like go eat out at a restaurant.
So I'm well aware of your procedure. So, but my concern is this section 2 really seems to be an overstep. But for instance, the restaurateur is concerned about a disturbance. The individual, I don't know why the individual would want to go back to the restaurant anyway. I know I wouldn't. I would be fearful that something, may be placed in the food or something like that. A lot of good restaurateurs out there, but I would be concerned about that. But you're telling me that even if the person has a concern, the restaurateur, that the individual may cause a disturbance inside of their restaurant as a result of them filing the complaint, they can't bar access?
The simple answer is they could, but then they're subjecting themselves to liability. So they could bar access, but then the person who's barred could file a complaint, and they may or may not win that complaint. And that's filed once it goes to investigation, or it goes further into a hearing. So it's not prohibiting the restaurant from doing it. It is that if it is based on discriminatory reason, that is illegal. So it's the discrimination that's illegal. It's not barring in a way that the criminal statutes bar.
But are you aware of strict liability statutes?
Yeah.
Okay, so given that scenario, concern of disruption, there is barring of access. Complaint is made. The determination by the CHRO is whether or not access was barred as a result of the filing of the complaint. And that's what this language says.
Right.
But concern of disruption, what does that mean?
Well,
what does that mean? I mean, I could go to a restaurant and somebody could be concerned that I might be disruptive without me demonstrating any kind of disruption. So I don't know what that means. Concern of disruption.
Well, the concern that somebody's going to stand up in the middle, I'm thinking of the IHOP restaurant. That's what I'm picturing in my mind. And the person's going to, go to various tables and say, hey, I filed a complaint against this place,
But how do you know that when someone gets to the door?
You don't. That's why it's
one second. I would ask us to be careful about the crosstalk. It becomes difficult to keep up. Thank you.
Thank you. Yes, it's mere concern of disruption, but there is no mitigating factors in this statute. It doesn't say that the restaurateur is given the opportunity to prove, business interest or that their barring was in good faith. None of that appears in the statute. It just says in a draconian fashion, if you bar access based upon the filing of a complaint, you are bad. That's what the language says. So it's a very, can be used in other scenarios as well, but it's a very troubling aspect of this proposed legislation. So thank you, Mr. Chairman.
Thank you, Representative. Representative Pavlik-Amato.
Hi, good morning. And thank you for your testimony. Just a couple questions, probably for clarification on the bill. I was looking lines 537 to 538. I was wondering, why are we removing that language? The language being subject only to conditions and limitations established by law and applicable alike to all persons. Why is that being removed? It seems like it's taking out the standard, general standard use.
To that now.
Are you in section 2? I'm sorry. Can you just tell me what section, because it'll be easier.
Section 13.
Oh, in section 13. And then, I'm sorry, can you restate your question now that I'm at the section?
Yeah, why are we removing the line would be subject only to conditions and limitations established by law and applicable alike to all persons? Why is that being taken out?
So in section 13, what we were attempting to do here, and we saw that there was some testimony in opposition to this section from the Hospital Association. What we were attempting to do here is allow for individuals in places of public accommodation to have the same rights as individuals in employment to be accommodated. And so the removal of that language was necessary in order for us to achieve that goal of making sure that individuals would be covered in places of public accommodation as well as in employment. But as their testimony indicates, we made reference to a federal statute, one section of that federal statute, and only for the purposes of discussing the interactive process. And we are looking at equity as opposed to equality. In most of our statutes, we're looking at equality, right? Treating people the same, but sometimes people with disabilities need different treatment because they need to be accommodated so that they can enjoy the same access that individuals who don't have disabilities enjoy. So it's not treating the same, treating an individual with a disability the same doesn't always work. Which is why we have reasonable accommodations in our employment statutes, and this would extend it to public accommodation, places of public accommodation as well, so that individuals who have disabilities can have the same access and equity as opposed to equality as everyone else.
Which I understand the intent, and that seems to address the rest of it, but that particular section, I mean, subject to limitations established by law, let's say, I mean, that just seems like a standard provision that you would need in there, because if there are other parts of the law, I mean, and I can't think of an example, but sometimes I know with, I'm thinking of, let's say, certain public accommodations, like I don't know, even a firehouse, where that, you know, the public doesn't come in and out necessarily, but and the firemen are staying there, and I know that's an exception, let's say, to having certain accommodations for disability. So I'm still confused as to why we're taking that out, only because, again, there's other laws that need to be, still have to be followed. And that seems to give that kind of buffer, and that concerns me. But well, I'll move on to my next question.
And can I just say that we're willing to work, we're willing to work with the committee on the language to make sure that any of the concerns raised are, certainly addressed, and that there's a complete and fleshed out understanding of what the intention of the language is, in to the extent that it's not clear, or the explanations are not as clear as you need them to be.
Yes, I think we were trying to achieve that the interactive process is required in public accommodations as well as in employment. And, we recognize that there may be situations with older buildings and things like that. And so the interactive process would be required here, just to make, situations more humane. By giving the disabled community greater access to public facilities, et cetera.
So now under this, which leads to my next point, the underline, the new language, which is still same section 543 to 554, discusses making reasonable accommodations for somebody with a disability. And public accommodation does include a rental property, even a single unit commercial rental property, correct? Commercial or residential?
We have housing, that would fall under our housing law. I think what you're referring to?
Yeah, so I'm wondering.
Public accommodation differ from where someone lives. That falls under housing, which is 46A 64C, as opposed to 46A 64, which is the section that we're referring to when we talk about places of public accommodation.
Right. Okay. All right. Because I was just looking that up, and it just seemed under when I looked up the definition of public accommodation, which is 46A-63, it includes any commercial property or building lot on which it is intended that a commercial building will be constructed or offered for sale or rent. So would that include somebody who's renting out a house or an apartment for to live?
So first you're talking about commercial space, and then you go to a house or an apartment. The house or apartment would be covered under the housing law. Commercial space could be deemed to be a place of public accommodation if it's used in the commercial sense that there's going to be a store there, or there's going to be a restaurant or a bodega or what have you. Then you're talking about a place of public accommodation. A place of public accommodation is where the public is invited for entertainment and amusement to receive services. So a place of public accommodation is a restaurant, a hospital, a store, a school, a university, a state agency when its services are being used, a police department, fire department. Those are places of public accommodation.
Okay. All right. Thank you for that clarification. My other question was I believe it's section 5, line 234. And that deals with allowing somebody to bring a claim to, it mentions filing in Hartford court specifically. And I'm just confused as to why it only Hartford court or Judicial District of Hartford and not any other judicial district, any other courthouse in the state, based on where the plaintiff or defendant live. Why is it only Hartford?
It says to add the Judicial District of Hartford to the list of permissible judicial districts where the commission can bring an action.
The commission may bring a petition in the Superior Court for the Judicial District of Hartford.
Yeah, so the intent here was to add the Judicial District of Hartford. That's where our central office is located, is in Hartford.
Right.
And
But
it's
shouldn't this be
to the
based on
list.
the plaintiff or the, well, if, I guess, would that make you the plaintiff then if you brought that petition? Or do you bring it on behalf of somebody else?
We bring it on behalf of the state of Connecticut. If we file a petition in court, we file ex rel, the party.
Mhm. So would this limit to, would it be only Hartford? Because, I mean, why not put it in the district? Shouldn't the defendant have the right to have it in a court closer to them and where they live? I mean, if somebody lives really far, it seems awfully inconvenient for somebody to have to travel to Hartford if they live all the way down, you know, on the other side of the state. Would this limit to only Hartford then?
So my understanding of the intent was to add Hartford to the list of judicial districts. I'm getting clarification because that was my understanding, that the intent of the legal department was to add Hartford to the judicial district. As I've tried cases all over the state, filed in various courts throughout the state. So hopefully in the next 30 seconds or so, someone will indicate whether that was the intent to limit it to Hartford, because that was not my understanding of what we were trying to do.
Correct.
Okay, and my last question, this, or two more, this extends the time that a complaint can be filed to, I believe it was 4 months before, now to 300 days. Is that correct? To add 6 more months onto the.
So what the current state of the law is that you have in an employment case and in a public accommodation case against the state of Connecticut, 300 days to file a complaint of discrimination from the date you knew or should have known that discrimination occurred. What this section is doing is clarifying and taking away some of the confusion, because in a public accommodation case that is not filed against the state of Connecticut, but filed against someone else, you get 180 days to file that public accommodation case. Also in housing, currently you get 180 days to file a complaint of discrimination as opposed to the 300 days. And so there was some confusion because the law was changed originally before the passage of the, I think it was included in the Time Up Act. There was 180 days to file any action, whether it's employment, public accommodation, credit transaction, or housing. And so the law will now be clear that in all cases where an individual is claiming that they were discriminated against, they would get 300 days to file their complaint of discrimination. Because now people have to parse out and they have to say, okay, well, if I'm filing a complaint, a public accommodation case against the state of Connecticut, I get 300 days. But if I'm filing against someone else, then I only get 180 days. But if I'm filing an employment case, I get 300 days. But if it's housing, it's 180 days. So we just wanted to move everything to 300 days. So then it's clear that the individual who has been, in their mind, subjected to illegal discriminatory conduct has 300 days to file.
Okay, I mean, I thought it was clear before. It just was different in different places. So, and my last question was, this now allows a CHRO employee to sign an affidavit.
Mm-hmm.
That I don't understand either. I mean, usually it's limited to attorneys and other listed individuals, but now it's just any employee of CHRO. I don't see why we're not, if we're going to do employees of CHRO, why not every employee who works for the state of Connecticut? I'm not sure why that's added on there.
It's so that the employees of the CHRO, whether they be an attorney or not, can administer the oath. When we take the complaints of discrimination, we take them under under oath. When we hold a fact-finding conference, the parties are placed under oath for the reliability of the information, and people seem to I don't know, be more truthful when they're under oath. And so it legitimizes their testimony in that they're saying it under oath. And so we want to ensure that not only will it be attorneys who are administering the oath, but it could be the investigators who now investigators can give an oath if they are take an oath if they have their notary.
Right. So why not require them the same? Why can't those employees be a notary as well?
It's just the cost, the cost to the state. We pay for the notary. We want to have every CHRO employee be able to administer the oath. We process about 4,600 complaints in a year, and so it's important to have with the sizes of offices shrinking, the number of employees shrinking, the number of employees in the office at one time being limited. There's a need to have it so that everyone can administer the oath.
But they could get it done at another. I mean, they could take it to a notary and get it notarized there.
Right, and then they may have a cost associated with that, and we don't charge for notarizing the complaint affidavit.
Right.
So.
Usually it's $5, I believe. So.
Well, some people don't have $5, and that's why. I mean, if you ask why we have included it, it's because the state of Connecticut wants to make their process of filing a complaint of discrimination one that's accessible to all, and not just those who would have money to pay for it. And $5 may seem small to some, but that may be large to others.
Right, but
I believe there are other agencies. I'm sorry.
That's not. I mean, having them sign something sworn doesn't limit access, their accessibility. They still have access to it. I mean, the person they go against has to get an attorney usually and spend thousands of dollars that way. So, I mean, that again, it always seems to be a balance. 300 days now. Now anybody in the department being able to sign that, always complainant, expanded accommodations for the complainant and nothing as far as equity goes for the other party.
So let me tell you a little bit about the equity for the other party, because respondents, we developed about 10 years ago a business training institute, and it is free, and we offer free training about what the law states, what the obligations and responsibilities are as it relates to landlords, as it relates to private businesses. And we have trained hundreds of thousands of employers through, or not employers, but employees of the employer, and thousands of employers with respect to the laws and how they work and how to avoid liability by having workplaces free of discrimination. We have enforcement authority, but we have an interest in making sure that respondents understand the law as well. And that's why we provide that free service. So we have the case assessment review process, which results in cases being summarily dismissed early on in the process. We have sped up the speed. We have sped up the time to process fully complaints of discrimination, because costs associated with complaints of discrimination can start to rise in terms of back pay. And so we made sure that we streamlined our processes so that respondents would not be paying these healthy back pay awards where they were found to have discriminated. So it definitely is a balanced approach from our side, because at different points in times we are either neutral when we're doing the investigation or the mediation, or we're prosecuting a complaint. Then we become more of an advocate on behalf of the state to eliminate discrimination. So all throughout our process, we have to balance the needs of both the complainant and the respondent. And we have made every attempt to do so fairly. And I think that we've come a long way. having tried a bunch of cases in Superior Court and at the Connecticut Supreme Court, and seen the costs that were associated for the state and for the respondent, we have taken those lessons and done everything we could to balance, to have a balanced approach.
And just one last question, if you could. I'm looking at line 272, which is, because I have you here for clarification, section 4. No, I think it's 5 actually.
Section 5, okay.
72, it talks about a petition, and that the commission will serve a petition by email. What is that? Is that like the initial petition that somebody would file when there's a discrimination case? Is that the petition it's referring to?
What were the lines again? I'm sorry. It's just like 272, 279.
Yeah, page 9. I just want to clarify what kind of petition that is.
While I'm looking that up, I wanted to clarify an earlier question about the Hartford Court. It adds Hartford as an option, as I said earlier, as the judicial district that the complaint can be filed in. However, it also allows for us to file the complaint where the respondent is located, which is how we take our complaints. It's based on the address of the respondent, because we have 4 regional offices, and depending on which region that particular town is in, that's where the complaint is taken, and that's where it can be filed as well. I just wanted to add that clarification.
Thank you.
And we will work with LCO to make those corrections as needed.
Yeah, I just with this, while you're looking, I just have a concern. It's, if this petition relates to taking somebody's property,
It's for injunctive relief. It's
right.
a petition, if that's what you're referring to, the petition for injunctive relief. Sometimes the discrimination that's happening, someone wants it to the person to be enjoined from engaging in whatever the conduct is, and so it's referring to that petition.
Yeah, I have a concern when we, in general, in Connecticut and elsewhere, have, when you're talking about something serious and, not exceeding, I'm seeing $25,000 here. Like, we usually require that be served in person. And, whenever there is some type of restriction of property or any type of freedom, it usually means in-service, in-person service. So, an email, that kind of worries me, only because it isn't necessarily the most reliable when it comes to, going to a spam folder or something like that. And I don't know how you would prove, that the person definitely said and saw and had notice, but, that's why we do in-person service. So again,
we're trying to save money for the state. Because the in-person service or service by a sheriff can get costly. We have a really small OE, and so we're always looking for opportunities to be able to have cost savings for the state. And it is not an initial. The email is not going to be the first time hearing from the CHRO. That email will have been in use, so we'll know that it's a working email. And there's an obligation on both sides to advise us if their email address changes. So,
and if the person, sometimes a person does opt for in court even, to receive it by mail if they don't have email. So under this, would a person who opts not to receive any electronic service, would they still be able to get it? I mean, it says by US mail, so I guess that.
And then the mailbox rule would apply. You assume when you put something in the mailbox, it makes it to the person that you're sending it to. So.
Right. Okay. All right. Thank you. I appreciate it.
Sure. Thank you.
Thank you, Representative. Comment or question from other members of the committee? Representative Fishbone for a second time.
Thank you, Mr. Chairman. Just want to take you back to, and I thank Representative D'Amato for her questions. Some of the stuff I did highlight, and I'm glad that she was able to get to it. The Hartford Judicial District issue. Now, you said that it added Hartford as an option, but presently you have Hartford as an option if the respondent or the discriminatory practice occurred in the Hartford Judicial District, right?
Yes.
So what this language does, it says, no matter where the discriminatory practice happened in the state, that the commission has the option of bringing all of those cases to Hartford. That's what this language does.
Yes, we would have that option, but we could also, it does not prohibit us, is what I'm saying, from bringing the action in the place where the respondent resides or where the discrimination occurred in the judicial district.
You and I both know you'll never do that. I mean, is there some sort of regulation that's going to be adopted that gives guidance as to whether or not the commission makes that determination? Because, you know, I have familiarity with this with other agencies, and I know they don't. So why would I believe that you're not just getting rid of that option?
So you don't have to believe us or think that we're trustworthy, but we are, and it would be not an intention to have a statutory provision that's just there to. We're not trying to fool anyone. We're trying to give the agency an option. We have attorneys all over the state that live all over the state because we have 4 regional offices, and so they can bring the cases in a specific judicial district where the respondent resides or where the discrimination occurred. But we also want to have that option available to us to bring the case in Hartford. And we are certainly working on amendment to our regulations now, and we can have regulations associated with it. I don't see that that's a problem. That's what the regulations are there for. But it's not our intent to bring every case in Hartford. We would have just, taken all the other options away and said, this is what our intent is, but that's certainly not it. We still intend to be filing cases in judicial districts across the state, but there may be instances where we need to file in the Hartford Judicial District.
With all due respect, you have no need for this language. The fact of the matter is, when would you ever employ this language? So presently, if an discriminatory practice happens in Southington, Hartford Judicial District, you, under the present language, you have to bring that action in Hartford, right? There wouldn't be any option otherwise. The only time you would be able to employ this language is when it's outside of the Hartford Judicial District, which, is a percentage of your cases. But, certainly if a discriminatory practice happens in Greenwich, then we are giving you the power of dragging the respondent, as well as perhaps the complainant, all the way up to Hartford. Otherwise, that's going to go to the Bridgeport court more than likely. If the discriminatory practice happens in Thompson, Connecticut, or is it, I believe it's Thomaston. We'll say with, the other corner, the upper right-hand corner, Putnam. We'll go to Putnam. Right now, that action would go to Putnam, but you would have the option of bringing it to Hartford. So and it's unilateral power. So I really see no need for that at all, and would not be in support of that. The email service issue, what procedure, because certainly we all get from time to time emails that go to our junk folders. What procedure is to be put into place that you're able to ascertain the service of an injunction in this case, which is a very high situation, by email would be effectuated? Because you can't do that in any other proceeding in this state. State court can't serve an injunction by email. Federal court can't serve an injunction by email. What policies and procedures are you anticipating, other than saving money, which I think is a dangerous place to go when we're talking about constitutional rights? What policies and procedures are supposed to go into place?
What we anticipate is that the parties would have already been being emailed regarding issues in the case, because it's not just the injunction, it's also in the housing election cases. They would have already been emailed, that they would have already received emails at that specific address. The individual state employees of our agency working to send the emails out would have to ensure that by double checking and having quality control measures in place, because we have a supervisor over each one of our departments, ensuring that the email went to the proper email address. Those would be some of the things that we have in place. Our intent is not to file a petition and not have the responding party know about it. Our intent is to make sure that the responding party knows about what's being filed, and also that both parties know in an election case that the case has been filed in court. I wanted to also just go back for a second. I don't know if you're aware of this, but currently our Office of Public Hearings, which is where our administrative law judges are housed, it doesn't matter where the case is filed, those cases actually are heard in Hartford if they're heard before the Office of Public Hearings. So we are not trying to pivot to a place where all court actions are heard in the Judicial District of Hartford. We're just trying to make sure that that's an option that is available to the agency. So it is not so far-fetched, because that's what the statute already reads as it relates to cases that are going to be heard administratively. This is to address cases that will be heard by the courts. So I don't think that it's that much of a heavy lift, and I just wanted to point that out in case that was something that people were not aware of, that is, the process already goes beyond what we're suggesting here as it relates to the judicial districts.
So presently, and I didn't want to backtrack, but you're getting me to backtrack. If the action is brought in Putnam under the present language, you're saying that it gets heard in Hartford?
If it's a public hearing, the administrative process, yes.
We're talking about this particular provision that's in lines 228 through 236.
Right. And
presently says may bring a petition in the Superior Court for the judicial district in which a discriminatory practice occurred. So utilizing that present language, the petition is brought in Putnam. You're saying that case is then heard in Hartford?
If it's a public hearing, if it is a complaint that's filed with us. I understand your question. You're asking about the current state of the proposed legislation. Will that case be heard in Hartford if this passes? Is that the question you're asking?
No, you told me that presently these cases are all heard in Hartford anyway, so it doesn't really do anything. But I don't believe that's the practice. I believe
I think there's a misunderstanding. So I want to clarify it for you. What I'm saying is, if someone files a complaint of discrimination with us, it goes through our investigative process. It's certified to public hearing. the public hearing is heard by an administrative law judge in Hartford, irrespective of where the incident of discrimination occurred. That's what I'm saying.
Okay,
So
we're talking about.
Sorry, I was giving you a comparison to state that we are not pivoting to such a different process because we already have this process in place for public hearings. And this would be a similar process, although we're talking about a judicial proceeding. That's the only analogy I was making for you.
Okay, but that's analogous to the legislature debating bills in the Capitol. It all happens in Hartford. There might be a bill having to do with just the town of Greenwich, but it gets debated in Hartford. But what we're talking about is the actual language of the adjudicative process that is anticipated by lines 228 through 236, which is not a public hearing. It's a adversarial situation. There's a complainant, a respondent, and a neutral. Under this language, if the action is filed by the commission in Putnam, the case is heard in Putnam, correct?
Can you you're saying with the current state of the law now,
Yes.
the action would be filed, it would be filed in Putnam.
And where is it heard?
And it would be heard in Putnam if you're talking about an injunction that's not going to public hearing, because public hearing, this is a dense subject. So at public hearing, you don't have, you said that you have like the complaining party, the responding party, and a neutral. At public hearing, that's not the case. At public hearing, the CHRO is putting the case on behalf of the state of Connecticut's mission to eliminate discrimination in the state of Connecticut. So so at public hearing, it's not the same as during the investigative process where you have a neutral fact finder who is trying to determine the facts in the case. And so that's why the comparison of going to public hearing or having the case heard at public hearing, which would be in Hartford, if it is a complaint that is filed, it would be heard in Hartford at the Office of Public Hearings. And if it were a complaint that was filed in Greenwich or Stamford or Putnam or Litchfield, it would all be heard in Hartford at the Office of Public Hearings. When we're talking about the specific lines that you're referring to, what we're attempting to do is to say that if the CHRO would have the authority to determine in what instances it's going to file the action in the Judicial District of Hartford. However, we would still have the ability to file that same action that I'm referring to in my example in the Judicial District where the discrimination occurred, where the respondent is located.
Do lines 228 through 236 have to do with a public hearing process? The section that we're talking about. It's a different.
If we're talking about the housing election, yes. If we're talking about an injunction being filed in court, no.
Okay, I'm going to go on. I know you were asked about this before, and I don't recall the answer. Had to do with your taking out, and I'm going to lines 537 through 538. You're proposing to remove the clause that says subject only to the conditions and limitations established by law and applicable alike to all persons. What is the reason for the removal of that clause?
Because individuals with disabilities need equity and not equality. They don't need the same thing as every other person. They may need additional things. They may need a reasonable accommodation in order to be able to enjoy equal access to places of public accommodations as others would.
But if other laws have created limitations, whether it be the federal law, other state statutes, why would the legislature then take this out of there? It seems counterintuitive. That's what you want to do. You want to take out, you want to make a strict liability statute. It doesn't matter what other laws are in effect. This rises to the top and this is it. That's the effect of taking out that clause. And I'm just trying to get to the intent.
So the intent is to ensure that places of public accommodation are covered by the law, and that individuals who need equity and not equality, individuals who need something different or something extra are covered by the public accommodation law. That's why that needs to be removed, and that's why we are suggesting that that language be removed, because it's been interpreted to mean that it doesn't apply to places of public accommodation. And so then therefore it is harmful to individuals who are trying to gain equal access to places of public accommodation.
So interpreted by whom?
There has been a decision, and I would have to get you the name of the decision where that was the determination. And so we're trying to make sure that individuals who have disabilities are covered in places of public accommodation.
There was a decision by a court, an individual. Yes. Okay. Supreme Court, Superior Court.
I don't have the case, but I can provide it to the committee. I don't
Sure,
have it.
That would be helpful.
Okay.
Thank you, Mr. Chairman.
Thank you, Representative Fishbein. Seeing no further comments, I want to thank Attorney Sharp and Executive Director Hughes for being before us. I know I've had a chance to discuss in depth the sections of this bill some weeks ago with you. I will note for the record, I raised and continue to share the concerns of many of my colleagues on the venue and service and some of the other provisions of this bill. I would suggest that the commission take another look at the bill and sharpen your pencils based on the feedback you've received from the committee here today, and get back to us on the bill and some potential substitute language to move forward. Next, we will hear from Chris Drake.
Thank you, Representative. My name is Chris Drake. I'm the Director of the Business Services Division at the Office of the Secretary of the State. I'm testifying on behalf of Secretary Merrill in support of House Bill 6605. I want to note first that this is our bill, except for sections 35 through 37, which I'll address at the end. So the majority of the bill is our bill that we submitted to the committee in support of our replacement of the Connecticut Business Registry, Concord. And that replacement itself is being done in conjunction with the larger Business One-Stop initiative that's being spearheaded by Governor Lamont and Secretary Merrill through the Department of Administrative Services. It's a large technology effort to drastically improve the business registration process in the state of Connecticut. And so our bill is to insist in that effort. I'll just highlight two things. So first, we're requesting that all businesses provide North American Industry Code information. At the beginning of this year, because of a previously passed bill, we started collecting that information with respect to annual reports. So this bill expands this and asks for that information on formations as well. We found that this information is incredibly helpful, and we've pointed to some examples in our testimony as to why we think that this is very useful information for us to take in and make publicly available. I also want to point out that sections 22 through 27 of the bill are an attempt to modernize the state's trade name statutes. So our trade name statutes, sometimes people call them sole proprietorships or doing business as DBAs. In Connecticut, we call them trade names, has not been updated in a very long time. So in conjunction with the Town Clerks Association, we worked on this language to kind of fill some of the gaps that have existed over a number of years, that town clerks have basically kind of invented certain procedures because the statute's simply silent on things like, can one renew a trade name, or can one amend a trade name, or can one cancel a trade name, or do they ever expire? Those questions different town clerks have answered differently, and so we're proposing this bill to fill those gaps. But most importantly, it's to begin the process of centralizing that information into our new business registry, and with the hopes that we can in the future provide a central business registry that contains this sole proprietor information that it currently doesn't contain at all, and that is dispersed among the town clerk's offices in the various towns. I finally just want to make a comment on sections 35 through 37. Those sections were not in our original draft. They appear to be an attempt to codify Governor Lamont's executive order on remote notarization. And we are respectfully requesting that the committee remove those sections from this bill and have the bill become back to its original focus on the business registration process. The executive order we supported, but it was never intended to be a long-term solution. We have done a lot of thought on this as an organization, as an office, and we have proposed what we consider to be a much more well thought out, considered effort, which is House Bill 6604, which is currently pending before the Commerce Committee. So we respectfully request that if there is a debate over the issue of remote notarization, that the debate be had in conjunction with that bill that our office has put forth. Thank you for the time.
Thank you. Just a question on the remote notarization. Why was that bill submitted to Commerce instead of to here, if you know?
I don't know why it was originated in the Commerce Committee. I can't answer that.
But that language is a proposal from your office?
Correct. So House Bill 6604 is another, my division of the Office of the Secretary of State. I understand the Elections Division has submitted many other bills, but my division has two bills, the bill before the committee today and that bill 6604, which is completely about remote notarization.
Further questions from the committee? Representative Fishbein?
Thank you, Mr. Chairman. Hey, Chris, how are you?
Good, Representative.
I don't know if you were here for the testimony on the prior testimony on CHRO. I know your office is in charge of approving individuals to be notaries across the state. That's how they apply to your office to become a notary, correct?
Correct. That's one of the duties of my division is to license notaries public in the state.
Yeah, I didn't know if you had your office had any position on the CHRO's proposal to have people who apparently don't take an oath to give oaths.
So, I was on during their testimony, so I'll just point out a few things. There is a carve out in the notary statute requiring our office to provide free notary licenses to other state agencies. So there's a particular one with respect to the Department of Public Safety. The legislature was so inclined, they could certainly carve out something for CHRO if cost was an issue for that. Connecticut, I believe, is somewhat unique in that in how many different officers we allow to do what are called notarial acts, so acknowledgements and attestations. So as you know, commissioners of the Superior Court, attorneys are allowed to do it, justices of the peace, town clerks. So it would be certainly adding one more type of officer who is not quite a notary public, but could otherwise sort of takes on the responsibility of being a notary public. In fact, our bill actually addresses that 6604. We call those people, we lump them together in a group and we call them notarial officers. Those are people who are not notaries public, but are otherwise authorized by statute to engage in notarial acts.
Yeah, understood. And I just, I note that in that bill, all of the described individuals are required to be sworn. Sworn law enforcement officers, sworn motor vehicle inspectors, so on and so forth. And this addition just says individuals employed by the Commission of Human Rights and Opportunities in the performance of their assigned duties. So, my distinction here is there's no requirement that those people be sworn. And I didn't know if there was a particular position that your office had with regard to individuals who aren't swearing other people to an attestation.
I think the preference is for people to become, who are non-attorneys, to become registered as notaries for the following reason. Our other bill with respect to notarization, it does a few more things besides remote notarization. And one of them is it provides a training course for notaries public that our office would be administering, sort of a continuing education course. This has been done in a lot of other states, and so one of the things that would be an advantage to becoming a truly licensed notary is that you would have the advantage of that once every 5-year course that says, here's how to do certain notarial acts, and here are the laws that that apply to being a notary public. I should also mention that we get quite a few notary applications from other state agencies. So I believe other state agencies in similar circumstances have just chosen to have their employees licensed as notaries.
Yeah, thank you. Thank you, Chris. Nice to see you again. And thank you, Mr. Chairman.
Thank you.
Further questions or comments from the committee? If not, thanks for being with us.
Thank you.
Next up will be Chase Rogers and Omar Williams, I believe, testifying together.
That's correct. Good afternoon.
Good afternoon.
It's an honor.
Go ahead.
It's an honor to be before the Judiciary Committee today to testify in support of HB 6548. Before my co-chair, Judge Williams, speaks, I just wanted to reinforce what Representative Blumenthal mentioned, that the task force, which was made up of an extremely diverse group of people in terms of background and perspective, was ultimately nearly unanimous in its recommendations, including those in the bill that you are considering today. In my experience, that kind of unanimity is quite unusual. So with that, I'd ask permission to defer to Judge Williams, after which we would both be happy to answer any questions that you may have.
All right, thank you all. Chairman Winfield, Chairman Staffstrom, Ranking Member Kissel, Ranking Member Fishbein, distinguished members of the Judiciary Committee, and thank you to former Chief Justice Rogers. My name is Omar Williams. I'm a judge of the Superior Court, and I'm here with Chase Rogers, former Chief Justice of our state's Supreme Court. We're proud to have served as co-chairs of the Jury Selection Task Force, and we're grateful for this opportunity to testify in support of House Bill 6548, an act concerning the recommendations of the Jury Selection Task Force. Racial and ethnic disparities are undeniable in our court statistics from any state. In October of 2020, Hearst Media reported that African Americans made up 12% of Connecticut's 2019 population, but 42.7% of our January 2020 prison population. Harvard's law school published a Massachusetts study this past September finding that Black and Latino residents are more likely to be stopped by police, searched, and arrested, to face more serious charges, and to receive longer jail sentences than our white residents. The Connecticut Supreme Court commissioned this task force to study the racial and ethnic discrimination in jury selection, to consider ways to diversify our jury pool, and to recommend rules or laws that would improve fairness. Chief Justice Richard A. Robinson of our Supreme Court appointed the members of the task force, which worked tirelessly and debated thoroughly before issuing its final recommendations. To make the jury pool more inclusive and diverse, the task force in Section 1 of the bill recommends extending potential service to non-citizens and to people convicted of a felony. It also recommends expanding the age at which a prospective juror can claim an exemption from 70 to 75. Section 2 of the bill addresses summoning. The task force found that our procedure substantially impacts minority representation. Our state is divided into 13 different judicial districts, and the task force suggests summoning potential jurors based on the proportion of a locality's population within each district, and then by considering how frequently people in an area show up for jury duty. When a summons is returned as undeliverable, Section 4 requires another one to go to that same zip code rather than to a location that might make up a smaller proportion of the district, that might be less diverse, and that might have a higher response rate. Section 5 requires collection of demographics while protecting identity, allowing the public to examine representation, who is summoned, who participates in a panel, who is removed by a challenge, and who is selected. This data allows us to pinpoint where underrepresented jurors exit the process, and it lets attorneys self-correct. To limit financial hardships, it suggests paying a minimum wage to jurors who are unemployed or who work part-time, and to reimburse travel expenses and family care. Additionally, for full-time workers whose jobs only pay for 5 days of service, the task force suggests paying minimum wage beyond that. Thank you very much for your time and attention to this matter. We're happy to answer any questions you may have.
Thank you, Judge. Representative Blumenthal.
Thank you, Mr. Chair. Thank you, Judge Williams, and thank you, Chief Justice Rogers, for being with us today, and especially for all your work on the task force. We operated under Chief Justice Robinson's aegis, but you all made the trains run on time, and I really appreciate it as a member. I was wondering, first of all, if you could talk a bit about what's not in this bill. I think there were some questions or some concerns voiced earlier about other places in the system where we could make improvements, especially around education and I guess kind of PR. What are some of the other areas that the task force addressed and that we decided did not need to happen through legislation?
Well, may I just ask a quick question, Representative Blumenthal, just so for clarity? Are you asking for things that were considered by the task force but were not proposed, or items that were that appear by way of changes other than legislation?
The latter. So things the task force recommended but decided statutory changes were not required to effectuate.
Okay.
I can speak to that a bit, and then why don't you pick up where I leave off. A significant amount of time was spent by one of the subcommittees on outreach to the community to try to interest people from diverse communities in serving. And so one of the interesting proposals and recommendations that came out of that was that we could really ask the bar and specifically some of the minority bar associations to help the judicial branch with that effort. And so we're hopeful, and again, these are at no cost. So, and I should mention, because I know this is always important to the legislature, most of the bill is at no cost to the state, but certainly outreach is going to be enhanced as a result of the committee's work. And then Judge Williams, do you want to add some of the other things that were recommended?
Sure, thank you, Chief Justice Rogers. There's also, there were recommendations regarding implicit bias, for example, modifying our model jury instruction as it pertains to implicit bias. First of all, the task force did a great job of looking at what other states are doing, and it found that Connecticut, in many respects, is doing some fantastic work. They did see one small area for improvement in that it would update our implicit bias jury instruction, and it would add it to civil trials as well, not just criminal trials, but it would impact civil and criminal trials, and that it would be done, it would be given by the trial judge at the start of a trial and at the end before deliberations begin. The task force also recommends a change in our practice book to address Batson claims, which were touched upon by the Chief Justice Robinson earlier today, and there are a number of other things that are outside of the legislative realm. One thing that Representative Blumenthal triggered in my mind, and thank you for your service, Representative Blumenthal, on the task force. You folks did a tremendous job. But if there's one other thing that we can emphasize, it's that these nearly unanimous recommendations, they're data-driven. These are data-driven recommendations. It's not just the product of some creative brainstorming, but of extensive research. If there wasn't empirical data to support a particular proposal, oftentimes a task force would opt not to pursue it. And that speaks to the true credibility of its work. It means that these proposals, if they're adopted, that there is evidence that they will be effective in reducing racial and ethnic bias in jury selection. It's the right thing to do, and this is a plan that helps us get there. One of those areas, just to give you an example, is in peremptory challenges. That's often an area that's recommended as being highlighted for change, or to limit the number of peremptory challenges, to entirely get away from them. The task force researched it, determined that there are some serious constitutional challenges there, and also found that there's not enough empirical data to suggest that tinkering with our system of peremptory challenges would necessarily reduce racial and ethnic bias. And so they simply didn't include that in our proposal. So while there are several proposals here and many of them work together, this is a data-driven set of recommendations. Thank you.
Thank you both. I appreciate that testimony. And I think it summarized perfectly the sentiment that, as you would expect from a task force full of lawyers, there was a sense of knowledge or inquiry, not only into what policy changes should be made, but who is capable of making them. And so, the task force took a really broad-based approach based on my observation. I think sounds like you would both agree. But not all of the recommendations are in this legislation. In fact, probably most of them are not, because the task force found that the branch could effectuate them on its own, and out of a sense of kind of judicial modesty and minimalism, there was a sense that what should be done what can be done through the branch should be done through the branch without asking the legislature to pass additional legislation. So to my colleagues who may be curious about what else the task force policies may be, I would encourage you to take a look at the report. There is a lot in there, a lot of great stuff in there that is not coming before us today that addresses these issues pretty comprehensively. So thank you both for your testimony, and thank you, Mr. Chair.
Thank you.
Thank you,
Representative. Representative O'Day.
Thank you very much, Mr. Chair, and thank you, Judge Williams and Chief Justice Rogers. Very much appreciate your testimony, and we miss you, Chief Justice Rogers, down in New Canaan. Couple of things, Your Honor. You had mentioned that not all the recommendations were unanimous. Can you tell us, in looking through, I have not had a chance to read the report, and shame on me for not doing so before this meeting, I apologize. But looking at the legislation, is there anything in the legislation itself that was not unanimous? And what were some of the concerns if there was something in here that was not unanimous, if you recall?
So the only one that I recall that has to do with the legislation was on the felon who has served their time. There was at least vigorous discussion, and I believe maybe one negative vote in terms of, for certain types of serious crimes, whether they should have to wait the full 7 years before they would be able to serve, as opposed to being immediately able to serve.
Thank you, Your Honor. And looking at, oh, I just missed the section on challenges for cause. Okay, here we go. Lines 179 to 187. Just from a practical standpoint, when in picking a jury, a lot of times in an effort to move things along, counsel will agree that a particular juror is not appropriate for a case, whether it's because they had a similar injury or they were leaning far too one way, whether it was for the plaintiff or for the defendant. So counsel will agree on a preemptory challenge. Some judges allow the lawyers to handle that on their own, or used to, and some require that you to go before the court and explain or get the judge's consent to allow a preemptory challenge. When tracking this information from line 179 to 187, oh yes, is it anticipated that is going to impact the ability of the lawyers to kind of agree on their own and just let the clerk know what happened with that juror? Or is this something that's going to foresee having judicial involvement or involvement from the judge for all types of challenges? I'm just wondering if that was discussed, or from a practical standpoint going forward, how that would be handled.
So I'm not aware of that scenario, which you're right, does occur on occasion, was discussed. Judge Williams, do you know?
I don't recall it actually being specifically discussed, but I don't think there's anything here that intends to stop that part of the process in any way.
Thank you. And I always tried to convince judges to allow the lawyers, when they're agreeable, to speed things along. And so, that's my hope. And in this new time of COVID, I think we're going to have a hard time getting jurors to serve, at least in the short term. So anything we can do to speed along the process. Well, thank you very much. My main question was really what recommendations were not unanimous and why. And thank you very much for your service. And I promise to read the report going forward. And thank you very much. Good to see you both.
Thank you.
Thank you, Representative O'Day.
Representative Rabimbus.
Thank you, Mr. Chair, and good afternoon, Your Honors. Thank you so much for being here with us. If I could just follow up a little bit on Representative O'Day's request regarding the items that were not unanimous. I know and I trust that the task force, as been previously stated, had many qualified, very experienced individuals on there, but I think we can all agree that even the most qualified, experienced individuals could also differ in certain opinions. Do you have, whether posted online or would you have access that you could share with this committee, the actual votes on the proposal before us and what may have had some disagreements?
So I can start on that. Where there was disagreement with regard to non-legislative recommendations, those dissents are recorded. In fact, there's a lengthy discussion. It's really only has to do with the Batson challenge, and there's a lengthy discussion of the opposing view with regard to one of the issues. With regard to the vote on the legislative material, I think that vote is reflected. And again, my recollection is that it was just the felony question as to whether a convicted felon who has served their time still had to wait 7 years, that it was just one person who spoke in favor of, with regard to certain kinds of crimes, that they should not be able to do so before they have been released for 7 years. I think that the information is certainly available and we can provide that to you to the extent it's not readily accessible.
Thank you, and I appreciate that. Another question in that regard as well is I'd like to flesh out a little bit in your testimony, or actually let me back up and just stay on that topic of legislative stuff versus non-legislative stuff that will need that will not need legislative action. Is that then go through a process of rules changes? What would be the process for you to incorporate the non-legislative required actions?
So I'll start. Some of it will require some practice book rule changes, which, as you know, then the Superior Court judges will have to vote on. Some of them are administrative changes that frankly are going to add more work for the branch, but this issue is considered to be so serious that they're willing to do so. So there's a combination of what's going to need to be done.
Okay, thank you for that explanation. I believe earlier that it was testified that one of the proposals was to extend this to non-citizens. Was that correct?
Permanently lawful non-citizens.
Okay. And when you say permanently lawful non-citizens, so it's my understanding that permanent residents who are legally lawfully in the United States currently can serve on the jury. Is that correct?
So I'm going to defer to Judge Williams because I don't want to make a mistake here. My understanding, though, is that this is how the subcommittee defined that was pursuant to federal legislation.
Yeah, and thank you, Chief Justice Rogers. Representative Rabimbas, thank you for the question. If you look at Section 1, which refers to proposed revisions to Section 51-217 of the general statutes, the task force is proposing adding the language of individuals lawfully admitted for permanent residence. And so that language was not in there. It said all jurors shall be electors or citizens of the United States who are residents of the state having a permanent place of abode in the state. And it goes on. So it would be adding lawfully admitted permanent residents. Right now, the data that we got from the jury administrator is that looking at the juror disqualifications during the 2019 court year, the task force found that 4% of them were disqualified for being non-citizens.
Okay, so I'd like to dive a little bit more into that, if you don't mind, and it probably isn't going to be in this forum only because I don't know if you've got that information readily available. But I can assure you that permanent residents, those who are lawfully here on green cards, actually do get notices for jury selection. Now, I'm curious as to your 4%, if they show up, if they're just being disqualified, then based on that, which puts into question why they are receiving the notices. But I'm also well aware with this jury selection that there's many times that people ask to be permanently removed from the list for a variety of different reasons, from disability all the way down to ages, and they still continuously get notices. I have to admit, it's quite annoying and I think costly for the branch to even be sending out these notices when people have asked for permanent removal from the lists. And I can assure you that I actually have submitted on behalf of individuals those letters, actual written requests, and they're still continuously receiving them. But with that said, I think we need to look further into that, because my concern, and I'll certainly voice it here and I'll voice it loudly, is those who are in the United States, other than through a legal means, permanent resident, if my understanding they're already eligible, if you're clarifying that because maybe they're getting these notices incorrectly and you want them to serve, I think we have to be very mindful of those, and this does, of course, excludes anyone that's born in the United States because they're automatic citizens. But those who are in the United States that are not citizens, There's a variety of different reasons why they're not. Some may not qualify whatsoever, but those who do qualify and could obtain their citizenship essentially may be making the decision not to take the oath, and the oath of which is to uphold the Constitution and the laws of the United States, as well as any state that they're residing in. And here we are asking them to serve on jury duty, judging certainly individuals who have, in certain circumstances, either committed a crime or have a civil offense, whatever the case may be. So I don't want to put you guys on the spot. Don't know what your debate was regarding what non-citizens actually includes or doesn't include, but I would certainly look forward to continuing this conversation so we have that information before this goes to a vote on this committee.
So I'm sure that the branch would be happy to, discuss that question further and also make the co-chairs available to you. As Judge Williams said, it specifically says as defined in 8 U.S.C. 1101 parens A20, and I don't have the language of that statute, but that may be helpful to you as well in determining what's actually was intended here.
Excellent. I'll look forward to that. Thank you so much.
And if I may, Representative Rabimbas, if I may as well, just supplement that by saying that I'll just point out that similar to the expansion that's being proposed to include or to prevent the necessary exclusion of convicted felons, there's nothing that precludes the parties from, during voir dire, examining to ferret out issues with regard to somebody being unfit to serve on any particular jury, whether it be a criminal one, a civil one, what have you. So they're still permitted to raise challenges for cause, which hopefully would cover some of what you're raising, and also peremptory challenges. So hopefully that would still ensure that we're getting people fit to serve on our juries. It just expands the diversity of the pool itself.
And I can appreciate that, certainly, and very familiar with the process of voir dire. I just don't know of any individual who in some way or form is not taking allegiance to the United States and may be actually taking action against our laws and the Constitution, who would openly admit during voir dire that that's the case. So again, I just think we just need to be very mindful as to what it actually is. And it might be the fact that just different courthouses are excluding people for different reasons. That has happened as well. So, this may not be an issue, or it certainly might be opening a door for some issues. So I'll just look forward to further clarifying that. And I guess another quick question in that regard, because we keep hearing about obviously some of the challenges that individuals have in their decision to serve on a jury, anywhere from employment to childcare. Did the task force look into the ability to potentially recruit individuals who might be unemployed?
So I'll start, yes. And that was actually a large aspect of what they were looking at in terms of economic barriers to people serving. And just to clarify from this morning, people who are unemployed and or part-time now will be paid a minimum wage for the 8 hours that they would be serving per day, and also provided child care and even broader family care. So if they have elderly relations that they're taking care of and they need to have coverage for the days they're serving, they will be reimbursed for that as well. Previously, as you know, it was only full-time employees who would be reimbursed to the tune of $50 a day after the 5 days that their employer was required to pay them. Now, after the 5 days, they will be, even full-time employees will be reimbursed by the state. If you decide to pass the statute, will be reimbursed at a minimum wage for the 8 hours that they serve per day.
Thank you for that clarification. Again, thank you for being here and providing your testimony. Thank you, Mr. Chairman.
Thank you. Further questions or comments from the committee? If not, I want to thank you both for being with us, and certainly for your service on this task force and dealing with what is a vitally important issue to our courts and to our state.
Thank you very much.
Thank you so much for the opportunity.
Next up will be former Attorney General Jepsen. Is George Jepson with us? All right, let's come back. Let's go to Judge Albus then. Good afternoon, Judge Albus. How are you?
Good afternoon.
Please proceed.
All right, thank you. Good afternoon, Senator Winfield, Representative Staffstrom, Senator Kissel, and Representative Fishbein, and members of the Judiciary Committee. Thank you for this opportunity to speak regarding House Bill 6505 regarding court operations. I would like to take a brief time here just to emphasize two aspects of the bill, which are detailed more in my written testimony. But they essentially both seek authority to continue doing some things that we did on a crisis basis during the pandemic that in fact have proven to be successful and that we would like to continue to be able to do. The first concerns the ability to have an applicant for a temporary restraining order file that application remotely. And there was nothing in the statute that prohibited that before, but there was a requirement that the application be accompanied by an affidavit under oath, sworn to before an officer like a notary public or most commonly a court clerk. So that practical requirement meant that in most cases, applicants had to come to court to get their application sworn to in front of a clerk. The executive order of the governor during the pandemic and this proposed legislation replace that requirement of an affidavit under oath with the requirement of a statement under penalty of false statement, which still carries criminal penalties if one says something untrue, but does not require a notary or clerk to administer an oath. And that makes it much easier for someone to file remotely. We've been working during the pandemic with the Connecticut Coalition Against Domestic Violence to help applicants use this process, and their help has been very beneficial. They've also assisted with getting applications served after judges have acted upon them, which also is something that would otherwise require an applicant to come to court to give the papers to a marshal for service. The other aspect of the bill would allow certain matters to be approved without necessity of a court hearing if the parties are in full agreement, both in family court matters and in family support magistrate court matters. Those do not include temporary restraining orders, by the way. Although the applications could be filed remotely, there would still be a hearing required in each case. But in divorce, custody, or support cases where the parties have reached a full agreement, they would have the option to request a court to act on their papers and even enter judgment without need for a court appearance. And this began during the pandemic out of necessity, but it's proven to be very successful and used widely. I'll note that the branch has been doing similar decisions for years in the non-adversarial divorce area, which was authorized by a statute passed in 2015, in which parties who met certain conditions could seek the approval of their divorce and the entry of judgment without having to come to court. We've also been doing temporary agreements on the papers without court appearance for several years. And those processes have been very successful, been essentially problem-free. So the proposed legislation would just expand that process to final agreements and judgments in these cases. There are several things to keep in mind. Number one is that this legislation does not seek authority for the court to decide any contested issues without a hearing. This is not for contested matters of fact. It's only for cases in which the parties have a full agreement. It's also only an option open to the parties. It's not something they're forced to do. If either party wishes to have a hearing, even when there is a full agreement, they will get a hearing. It's only when it's chosen by the parties at their option. There are safeguards in the sense of not allowing this process to be used in any case where there is a pending or in force restraining order or protective order between the parties. That was a similar provision that was put in the non-adversarial divorce legislation of 2015 that I referred to earlier, for fear that there could be some undue pressure in those cases. Parties in those cases still need a hearing and cannot use this process. And finally, the papers upon submission are still carefully reviewed by a judge. Judges during the past months could and have required hearings after reviewing the documents if they felt something either was not self-explanatory or was missing or was one-sided. So ultimately, a judge would decide whether he or she needed more information before acting. But allowing this process to continue will enable many parties who choose to do so to save time and money from coming to court, lost time from work, and it'll also help to free up court time to devote to those matters which are contested.
Thank you, Judge. I know we have some questions for you. Representative Fishbein.
Thank you, Mr. Chairman. Good morning, Your Honor. Nice to see you again.
Good to see you.
Judge, just want to take you through some of the aspects of this. And, starting with line 569, that has to do with being on state assistance or getting benefits from the state. And you've inserted in the language that representation that there is no restraining order. We're going to get to the reasoning for that with other aspects, but why particularly with regard to this provision is this necessary?
The intent really was to make sure that this process of proceeding without a hearing and each element of the process, like the finding described in that subsection, would not be available if there were a restraining or protective order between the parties or there was an application for one pending. Again, on the theory that in those cases where there might be an element of undue pressure, that there should be a hearing and that this affidavit procedure wouldn't be available.
I understand the overarching reasoning for it, but sir, do you have the bill in front of you?
I do have that section of it.
Okay. And this section, starting at line 560, that has to do with findings as to whether or not the parties have some sort of financial assistance from the state. And I'm just trying to figure out why this representation would have anything to do with that. You understand my concern?
I do. I think that language is there because of the requirement of a finding that the expenses be documented and identified on the record. And in the past, that's always been at a hearing. This change reflects the possibility that if this statute is passed, that finding might be made on the basis of affidavits. But it just reiterates that the affidavit process would not be available in a case where there was a restraining or protective order involved.
Understanding that, but the proceeding itself can't proceed without that representation, correct? This is under the magistrate's portion, I believe.
Well, it is under the magistrate's portion, and the proceeding would happen. It just could not happen on the basis of an affidavit as opposed to a hearing if that condition weren't met.
Okay. Now, shifting to lines 911 through 912, which clarifies that affidavit for a 46B15 restraining order. Presently, it says it has to be an affidavit under oath, but now we're tying that to a specific crime, 53A 157B. Am I to understand that that would be the sole remedy if somebody lied on a restraining order application, that it would be discretionary upon law enforcement whether or not to go after that individual.
I don't think the intent was to make that the sole remedy. There might be other remedies in the civil context, but when an oath was required, if someone lied under oath, that potentially is perjury, which is a more serious crime than making a statement under false statement. The purpose of that language was to make it clear that that was a statute being invoked, and that statute says that if it's specifically invoked and cited on the document that you're signing, then the penalties of the law apply. So I don't think that's any more restrictive on other remedies than it was when we said it had to be under oath. It just changes the nature of the potential criminal ramifications.
Okay, so we're doing a couple things here. We're lowering the bar from when somebody lies under oath on a 46B15 restraining order from perjury to this Class A misdemeanor,
right?
Which is troubling. And we're not, I mean, I read that to be that, well, I guess you could bring a civil action. You'd have to allege the element of the criminal action in the civil action. Okay, I'm just concerned with the lower end of the bar there. Moving on to lines 1256 through 1265. And I believe this has to do with a 46B16A restraining order, which is parties that are not, don't share a child, not related by blood or marriage, could be two neighbors. This provision allows for, if there hasn't been service of the ex parte order, for the hearing date to be extended. Is that fair to say?
Yes.
And is there a similar procedure with regard to a 46B15 restraining order, though?
There is, and I neglected to mention in my remarks that part of this bill, although it's most of it has to do with family actions, does make similar changes or propose similar changes in the civil protection order statutes, including the penalty of false statement change, which was also done under executive order of the governor during the pandemic. And to add this provision, there already was in 46B-15 a provision to allow for a postponement of up to 14 days in the hearing if needed to allow for service and the extension of the ex parte order for that time. I would have to defer to the civil judges, but my understanding is that option did not exist under a civil protective order before, and this bill would add that same provision in a proceeding for a civil protection order.
Okay. Now, moving to line 1361 through 1368, that allows for an affidavit to rise to the level of permitting the court to make a finding as required by the underlying case. Am I to interpret that any other way?
No, that's correct.
And in what form of cases would that be used? Would that power be used?
That would be used in cases where the parties had a full agreement. And there are certain statutory findings that are required in divorce and custody cases that normally would be covered through the evidence at a hearing, but under this procedure would be addressed through the affidavits. For example, a finding that in a dissolution that the marriage had broken down irretrievably. In child support orders, if there's to be a deviation from the child support guidelines, the statute specifically requires certain findings to be made by the court. If the parties are waiving their right later to seek an educational support order about college expenses. There's a statute that requires the court to make a specific finding that they have done so knowingly and willingly. So even if the parties have a full agreement, there are still some findings the court has to make. And the bill includes the creation of the possibility for each of those findings that it could be made by way of an affidavit, on the basis of an affidavit, by way of a finding stated in writing by the court in its decision. But again, the only situations in which this would be used or is intended to be used is where the parties have a full agreement and seek this alternative process.
Now, these affidavits that we've been talking about, they don't fall within the same criminal criteria as the affidavit for a restraining order, right?
The affidavits would be under oath before a notary or clerk of the court in the traditional manner. They would not be subject to the relaxed penalty of false statement law.
Understood. Some of my colleagues have expressed a concern, lawyer colleagues, not legislative colleagues, that a portion of these sections would permit certain evidentiary or certain findings of fact to be found by the court by affidavit as opposed to a hearing, and there's a constitutional problem there. Do you recognize that problem with any part of this language?
I don't, not when there's a full agreement of the parties who choose to use this process. And if there's confusion and there's a belief that this language is going to be used to deprive someone of a hearing on a contested issue or the right to cross-examine a witness about a contested issue, that is not at all the intent. And I would certainly be happy to work with the committee on making that clear if it's not clear already.
Well, I thank you for that. I think there'll be some lawyers testifying later on today that may bring their concerns to the attention of this committee. And I hope that we're given the opportunity to ask about the specific language. With that, Judge, thank you and have a good day.
Thank you, you too.
Representative Howard.
Good afternoon. Thank you, Mr. Chairman. Good afternoon, Your Honor. I just,
Yes,
just a brief thing on the last exchange. One of the, let me tell you first that in my professional experience, I've seen ex parte restraining orders work very, very well in getting folks relief from abuse. And I've, used them with people I've been working with very recently, and they work well. But I've also seen them where judges err on the side of caution and issue them when perhaps, the facts presented were notably questionable. And the reason I bring this up is because by making a false statement, my opinion is that oftentimes state's attorneys in certain cases, whether it's domestic violence victims, sexual assault victims, etc., or reporters, I should say, more than victims, they're less likely to ask for or agree to prosecution on folks who makes false statement on those cases out of fear of being a deterrent from others coming forward. Do you see that happening? Do you agree with me that happens?
I can't really comment on what prosecutors may or may not do. I will say that we have used this process for close to a year now. I haven't noticed a qualitative difference between what's stated in allegations in the applications and what comes out at the hearing later. And I understand the concern about lessening the standard. That's the decision of the legislature to make. But in our view, it was a way of still making applicants bound legally to tell the truth and enabling those who could not, for whatever reason, conveniently come to the courthouse to file remotely and get their hearing.
Okay. And over the last 12 months, it's been working in your best estimation?
I think it's been working well. I think it's provided better access to the courts, and ultimately, everyone gets a hearing. And as I say, I haven't seen a difference between the before and after. If we're talking about comparing what's alleged in the application and what parties then say when they come to court and are put under oath.
The same.
I haven't noticed any appreciable difference. And that's not to say that everyone is always found to have been telling the truth both times,
Sure.
but I don't think the different standard of being bound to tell the truth has made a qualitative difference, at least not in the applications I've seen, based on the evidence that comes out at a hearing.
Okay. Thank you, Your Honor. Thank you, Mr. Chairman.
Thank you. Further questions or comments? If not, Judge Albus, thanks for being with us.
Thank you, and I apologize to Attorney Jepson for jumping the line in front of him.
No, not at all.
Thank you.
My fault.
Attorney General Jepson, you're up next. Go ahead, sir.
Thank you. Committee chairs, ranking members, members of the committee. First, an apology for screwing up with my computer a few minutes ago. But thank you for the opportunity to speak in favor of Senate Bill 988, an act concerning judicial compensation. I'd like to start by thanking my fellow commission members. They worked very hard, and especially to thank the staff that made it all possible. That would be Duke Chen from OLR, Deb Blanchard from the Judiciary Committee, and from my own staff, Emily Westerberg. Chief Justice Robinson went into detail about the commission's statutory charge, so I'll skip that and go straight to the commission's findings. The current base salary for a judge, a trial court judge, is $172,000, not the number that was reported earlier. And judges have had only one raise since 2015, and that was for 3%. If they kept pace with inflation, salaries would be today around $184,000, or roughly $12,000 more than how they are currently compensated. This gradual erosion in judicial compensation has prompted the National Center for State Courts to report that Connecticut dropped on a cost of living adjusted basis from 26th in the nation for the amount it pays its trial judges to 40th in the nation. To bring us back to that 26th position, which is kind of in the middle of the pack, would require compensation of approximately $198,000 per year. One result was discussed, Chief Justice Robinson did a great job discussing one of the results of this gradual reduction in compensation, which is that it has become increasingly difficult to recruit from the ranks of senior lawyers, people with lawyers with meaningful experience in areas of litigation and commercial transactions to serve on the bench. And in fact, in rough terms, since the 90s, the percentage of judges who have come from the private sector has gone from approximately 75% to a little bit over 60%. And so that speaks very clearly about the compensation issue that Chief Justice Robinson discussed. This begs the question that in these troubling economic and budgetary times, can the state of Connecticut afford to provide meaningful increases in compensation to its judges? The consensus position from the commission was that yes, it can, at least to some degree. We believe very strongly that having a competent, diverse judiciary is foundational to the rule of law and having a properly functioning representative democracy. The commission also agreed on a consensus basis with Chief Justice Robinson's recommendations. We thought that they were a thoughtful and affordable step forward. If implemented, it would result in a 4.5% increase in compensation in calendar 2021, which would bring judicial salaries up to approximately $180,000 per year. And then in the 3 years succeeding that, with a 2.5% COLA, would bring judicial compensation to roughly $194,000 in the year 2025. Not a budget buster, but a meaningful step forward. Connecticut would still rank in the bottom half of the 50 states, but we would be much closer to the middle. We believe that this measured, thoughtful, and we think common sense support measure deserves your support. Thank you for having me.
Thank you. Are there questions or comments from the committee? Seeing none. Jim Jepson, good to see you. Thanks for being with us. And
Nice to see everybody. Thank you.
back to the Judiciary Committee. All right, next up will be Carmine Perry.
Good afternoon, members of the committee, and thank you very much for your time. I appreciate it. I'm speaking on behalf of the Elder Law section today in support of Senate Bill 940. The bill is about respecting probate court orders when a party has one, notice of the proceedings, and all the various parties have, including but not limited to, the right to be heard, the right to inquire and explore various different positions or end party positions in the probate court or at the probate court level, and the right to appeal if need be. With respect, and I'm sure folks already know this, but with respect to the probate court, this suggested revision to 45A 186 does not expand probate court jurisdiction, powers, or authority. It's a statutory court with a statutory framework. The bill just asks those to work within the greater framework of our system, which the probate court does, as confined in or found in 45A 98, among other places, with respect to probate court jurisdiction and authority. With respect to the rules of procedure in probate court, there are rules now in place where folks can testify electronically, participating in various different proceedings. This was in place pre-pandemic, but now during the pandemic, having had the opportunity to practice in various probate courts throughout the state, folks can call in. You can call in or video in from anywhere. I don't have to tell all of you, you know that. Whether you're in your office, your home, I've seen cars, I've been outdoors, see people logging in outdoors from anywhere. So access to the courts and the probate courts, which have been pretty nimble in these times, has assisted those who to participate in these various proceedings. So it doesn't make it more onerous for an agency or one on behalf of an agency. You simply go to WebEx and you log in if need be. I've had the opportunity and the privilege to be able to argue an issue like this before the Supreme Court recently, as of early 2018, in the case of Valieri versus Commissioner of Social Services. In that case, the Supreme Court held that the plain and unambiguous language of various statutes and federal law provide that a Department of Social Services, in a case of a community spouse allowance, must follow a probate court order if it has notice. I was merely a conduit between the law and Judge Caesar Noble, who issued a decision in the Superior Court level, and then it went up to the Supreme Court. I was merely a conduit of the framework of the law. And frankly, that's what I think this bill is. I think this bill, which is being proposed by Senator Kelly, which the Elder Law section is in support of, merely codifies the process. It doesn't expand, it doesn't change, it doesn't revise at all. It just simply reflects what the process is. And more importantly, forget what I have to say, just look at the Valieri decision, what the Supreme Court had to say with respect to an issue very much relevant and related to this. So the Elder Law section's in support of it. We ask you to approve it, and I appreciate your time.
Thank you. Questions or comments from the committee? Seeing none, Attorney Perry, good to see you again. Thanks for being with us.
Good to see you. Thank you all. Be well.
Next up will be Scott White. Is Dr. White with us?
One moment, sorry, I'm just trying to.
No, not rename.
Sorry, I'm trying to get the camera on, but it doesn't seem to want to. Oh, wait, hang on, see it.
There you are. There you go. There you go. Hi.
All right. Hi. Sorry. My apologies. I literally just came out of surgery. So I'm in the recovery room right now.
Well, this is definitely a first before the Judiciary Committee. I think you probably get our award for most dedication. So go ahead.
All right. So I'll try and be brief. I don't think I'm too groggy. I think the bill was 939, but I don't have the paperwork in front of me. I believe I'm the only testifier on behalf of this bill. I am a emergency physician, St. Mary's Hospital. I'm the team doctor for Waterbury Regional SWAT team. I am one of, I believe, 4 in the state. You probably have some other written testimonies from Rich Kamen and Adrian Mong. Hopefully I have some written testimony from my captain and some others. This bill has been put up before. I came and testified in person in 2019 for the bill, and it was objected due to being a redundant surgery for Good Samaritan law. The bill, the purpose is not for medical coverage. We, as physicians have discussed this, we were covered, we understand, through the Good Sam law, plus our general medical malpractice will cover us for treating our team members, civilians, and even suspects. Our concern is civil liability. We're not sworn officers. We don't go to the academy. We do go to SWAT school and other things for training. If, and as legislation has been passed, the likelihood a team gets sued, then the team would have the town representative suing them or representing them. However, the likelihood is we'd be sort of separated from the team because we're not part of the sworn officers, and would be responsible for our own civil defense. And although in discussing with other lawyers, the possibility that we'd get significant sued, lose our houses, our retirements, etc., we would have to pay for our own defense. And if we lost, losing our personal assets, trying to help voluntarily to our team members and the community at large, we're hoping to avoid that. It seems a little unreasonable that we would have to risk that. We're asking for protection at whatever level it might occur to avoid civil prosecution, working as volunteer agents for the various communities. I'm with Waterbury Regional. There's one doctor at Yale that's with New Haven, 2 other doctors, Dr. Kyle and Kamen, that are with North Central. And then I don't know if Steve Wolf out of St. Francis is still with a Hartford Regional. But as we saw down in Washington, SWAT team plus the National Guard plus Capitol Police all called to respond to civil unrest down there.
Dr. White, Dr. White.
Yes.
Your time has elapsed, so if you could summarize.
Okay. My summary then would be we're there because the point of wounding care is important. We're hoping to have some type of protection from civil liability because we can't purchase it. We don't have it. We're not looking as much for medical coverage through Good Sam or otherwise. And if anything we could do to get that would be extremely helpful to our cause or to ability to continue as volunteers.
Thank you very much for your testimony. Good afternoon, Senator Champagne. You have the floor.
Thank you, Doc. I have a question for you. Can you just explain a little more what your role with the SWAT team is?
Role is essentially just medical. So, so if someone is injured with penetrating trauma, if they start to bleed, they can bleed out in as little as 3 minutes. So past paradigm has been that EMS, docs, whoever, et cetera, stages outside, areas made secure, safe, and then they go in. That can be 5 minutes, can be 5 hours. Having personally watched someone bleed to death, I can tell you it's not something I ever want to experience again. Being part of the stack is means not, going. I'm not the first one through. I'm not the breacher. I'm not anything else. Nor are the other docs. But if someone goes down, whether it's one of the team members, it's someone in the house or building, if it's mass casualty, we're right there. We're carrying packs on our back with medical equipment to treat as many as we can, as quickly as we can, to try and stem death from bleeding and or airway complications, etc. So our focus isn't on, face-to-face confrontation with the rest of whatever's going on. It's about keeping the people safe that are injured and just being there when they need us.
Right. And thank you for doing that, by the way. And given that you're with the SWAT team, that basically exposes you quite a bit. Now, when we look at this, essentially, in that situation, in the unfolding chaos, that probably exposes you a lot to suits as well.
That's our fear, yes.
Well, you're under gunfire. I mean, I personally would be concerned about that. And in order to become a volunteer to do this, I mean, what do you think those people that do what you're doing, what do you think should be their qualifications?
So I think they should definitely be vetted by whatever municipality is going to use them. I can tell you, I don't know if anyone on the panel has served before, but your teammates will know whether you're a valid, useful member or you're just in the rear with the gear serving no purpose. I think that every volunteer should attend training as far as SWAT school, definitely, because you need to know movements, tactics, etc. I'll be honest, when I first started, I thought, all right, well, I'll go attend the academy and I'll get sworn, etc. Then there'll be no question, but I don't have 8 months of my life and my salary to donate to the police department to get that credentialing.
Right.
So I think at the very least, there should be every year, not right now, obviously, but I pass, and so do the other docs, the PT that the rest of the officers do. So we have to run, carry gear, drag someone off the field, etc., to be useful. And so physically understanding movements, understanding sorry, I'm beeping because I'm setting off the alarms. Should be validated, should be qualified to do what they're there to do. So if I'm 500 pounds and I can't move, I shouldn't be on the team.
Right.
But I believe it would to sort of overview, some sort of state or municipality level saying, okay, you will cover us if we are named in a civil suit. Mm-hmm. Then municipality or state level to say, okay, you're physically, mentally, medically competent to go help the team. I wouldn't want to see every medical provider out there say, hey, I want to be on the SWAT team and just show up and start working, because I think that would be dangerous and foolish. So
Right,
I think there should definitely be a minimal amount of required certification. But to get there, I think we need to say, yes, if the team gets sued, you won't lose your house, you won't lose your pension, you won't lose your retirement, et cetera.
right. And one other thing, and just so everybody's clear, you're not there just to protect the officers. You're there to help the victims. And in some cases, you may be helping the suspect. Is that correct?
That is correct. And, that's been asked previously. There are, I don't know if it's case law, but there are examples of the medical provider on the team actually treating only the suspect because they're the only ones injured. And, my obligation as a medical provider is to provide care to those that are injured.
Save lives.
Trying to, and, you can name whatever your particular mass casualty incident is, when show up in the Bearcat, the MRAP, whatever your vehicle is, you offload, the officers are going to try and control the situation. But from there, who's the worst, who gets initial treatment before they bleed to death, which, as I said, wakes me up at night still from my prior experiences. So trying to prevent that.
Just a quick little side. Do you get any of the medics coming off the battlefield and the technology and stuff they're learning with the quick clot, the tourniquets, and the rest of that? Do you get updated on all that?
Well, if I can take just a moment, it's not a sales pitch, but myself and my buddy, who's Green Beret, still reserve duty, own a company called East Coast Tac Med. We teach combat medicine around the year to civilians, but first responders, et cetera. Twice a month, I volunteer my time at the police training center that officers coming in learn beacon, bleeding control. So they get tourniquets, combat gauze, how to sort of get in safely and apply this medicine. I have them do it to themselves so they know that it hurts, because that's, people take them off. I also teach at schools, at hospitals. I'd be happy to come up and teach the senators. We saw the Capitol insurgents. I'd love to see everyone up there have at least stations with tourniquets, combat gauze, et cetera. And again, I'll say it sticks with you when you watch a friend bleed to death. I'd be happy to teach everyone up there bleeding control. So yes, I get updates. I also do work for the DOD through a subdivision of the Army on, I'm not allowed to talk about stuff, but what's coming up and that sort of thing. So there's going to be greater and greater amounts of bleeding control in the future.
All right. Thank you very much. And thank you for your volunteer work. It's much appreciated.
Well, thank you. I appreciate that.
Thank you, Senator Champagne. Is there a comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us, and I wish you a speedy recovery.
Thank you, sir. I appreciate it.
Next, we have Senator Kelly is with us, Representative Cheeseman, and then Christine Orts. Senator Kelly, you have your 3 minutes.
Thank you very much, Mr. Chairman, and thank you, Chairman Staffstrom, as well as ranking members Kissel and Fishbein. I appreciate the opportunity to submit testimony and speak in support of Senate Bill 940, an act concerning state agency compliance with probate court orders. This bill basically would make probate court orders decrees binding on state agencies when the probate court has jurisdiction over a subject matter. Fairly straightforward. For instance, probate courts have statutory jurisdiction over trust constructions and determining property ownership interests. Once that determination is made, a state agency must not be allowed to disregard that order in administering its respective programs. Unfortunately, this happens often in the Medicaid program. A probate court will issue a decree construing a trust or ownership in property, And then the Department of Social Services, in determining Medicaid eligibility, disregards that court decree. The practice in which state agencies have disregarded probate court rulings has caused confusion and jeopardizes the careful system of rule of law that guides the probate court's unique role in sensitive matters, including issues such as children, developmentally disabled adults, trusts, estates, and other issues. The bill does not give authority to courts to make Medicaid eligibility determinations, nor does it give DSS the authority to issue court decrees. What it is designed to do is to clarify statutory authority of the court and DSS and to give full force and authority to their respective decisions. Thank you very much for the opportunity to be with you today. And if anyone has any questions, I'd be more than happy to answer them.
Thank you, Senator Kelly. Is there a comment or question from members of the committee? Comment or question? Senator Kelly, I do not see any. I want to thank you very much for joining us this afternoon, and have a great rest of the day.
And you do likewise. Thank you very much.
All right, next we'll hear from Representative Cheeseman, followed by Christine Orts, and then Richard Hogan. Representative Cheeseman, you have 3 minutes.
Thank you. And I don't think I'll need all 3 minutes. Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and distinguished members of the Judiciary Committee. I'm here to support SB 1023, Section 7, which was you talked about before with CHRO. When the bill was passed mandating 2 hours of sexual harassment prevention training for all employers with more than 3 employees, there was no provision made for those employees who might work for multiple employers. As a result, for each employer, you are required to give that training, 2-hour training to each new employee. Now, CHRO pre-COVID submitted a fix for this. I inquired, I run a children's museum, and obviously I'm in the state legislature, and I asked, would one, fulfill the terms of the other, and no. So this is a provision that would in effect stipulate that if you receive the required recognized 2-hour training from one employer, you would not then be required to receive it from 1 or 2 more employers. Good bill, ought to pass. This provision will certainly make it easier both for the employees who don't now have to sit through 6 hours or whatever, and the employers who are not forced to, did you take it? Well, I still have to give it to you anyway. So I don't think if they're having any questions, I'm happy to take them. But as I say, this seems a very common sense fix, and one of those things that sometimes happens when we pass legislation and we are required to go back and just make little tweaks to it. So.
Thank you, Representative Cheeseman, and Representative O'Day.
Thank you, Mr. Chair, and thank you, Representative Cheeseman, for your testimony. I'm not aware of anybody that would are objecting to this bill. Are you aware of anybody that would are opposing this?
No, absolutely not. And I submitted my own bill 5190, which has this provision. It just, this is a common sense fix. It's included in the agency's bill. And I just want to make sure it stays in there, because you shouldn't have to get trained more. Training's important, but you shouldn't have to do it 2 or 3 times, nor should 2 or 3 employers have to pay to train the same person. So.
Agree completely. Thank you very much for your testimony here today.
Thank you. Thank you for hearing me. Have fun, guys.
Thank you, Representative O'Day. Representative Quinn.
And I'll just echo the comments of Representative O'Day. Having gone through this 3 times myself, I completely agree with this fix, and thank you for your testimony today, Representative Cheeseman.
Thank you. Happy to be here.
Sorry about that. Thank you, Representative Quinn. Comment or question from members of the committee? Comment or question? I do not see any representatives, so thank you for joining us today. I hope you enjoy the rest of the afternoon.
Thank you. You as well.
Next, we'll hear from Christine Orts, followed by Richard Hogan and Daniel Krish. Ms. Orts, you have your 3 minutes.
Yes, good afternoon, Chairman Winfield, Chairman Staffstrom, and members of the Judiciary Committee. My name is Christine Mannix. I'm the current president of the Connecticut Court Reporters Association and owner of Mannix and Mancini Court Reporting Services. I have been a stenographic court reporter in Connecticut for the past 30 years, and I am appearing today to speak on behalf of stenographers in Connecticut with regards to proposed House Bill 6605, an act concerning business registrations, trade names, commercial recording division within the Office of the Secretary of the State, commercial registered agents, and remote notarial acts. As a result of the pandemic, Stenographers, like many others, were unable to work for a period of time. Fortunately, because of Executive Orders 7K and 7Q, we were able to resume working in a remote fashion due to the remote notary provision in those executive orders. We would like to codify the provisions in those executive orders so that stenographic court reporters can continue to work remotely. Initially, this order allowed stenographers to continue working as most law practices, schools, and places of employment were closed to the public. Along the way, many benefits of this remote practice became apparent. Attorneys, stenographers, and parties were able to continue the judicial process in a safe environment. This process also allowed the stenographers and the attorneys to be more efficient by fitting multiple depositions and other proceedings into a day because there was no travel involved. Snow days were a thing of the past, thus increased productivity for all. And parents who were unable to send their children to school or to daycare were still able to participate remotely. Sections 35 through 37 of HB 6605 effectively codify the governor's executive orders, allowing notarial acts to take place remotely, so long as certain parameters are met regarding proper identification of the notary, witnesses, and other present parties. CCRA fully supports these sections and urges their remained inclusion in this bill. As April approaches and a possible end to the executive orders that allow us to continue working draws near, stenographers have expressed concern that these orders need to be extended and that we endeavor to create a law that will allow this practice of remote administration by court reporters to continue indefinitely. I urge you to consider this to keep Connecticut stenographic reporters working through the duration of the pandemic and beyond. Thank you, and I'm happy to answer any questions you may have.
Thank you very much, Ms. Mannix. Are there comments or questions from members of the committee? Comment or question? I do not see any. Thank you very much for joining us today. I hope you enjoy the rest of the day.
Thank you. As well.
Next, we'll hear from Richard Hogan, followed by Daniel Krish, Representative Clarice Ditria, and then Kate Wall. Mr. Hogan, you have your 3 minutes.
Good afternoon, members of the Judiciary Committee. My name is Richard Hogan. I'm the Chief Compliance Officer for Connecticut Attorneys Title Insurance Company. That's a company that's headquartered here in Connecticut, represents a little over 800 law firms throughout the state. I'm here to talk about House Bill 6605. If you remember, that was a bill introduced by the Secretary of State's office, and Chris Drake testified earlier at your committee that sections 35 through 37 of the bill ought to be removed, as they were never intended to be made into a full statute. Sections 35 through 37 really codify an executive order issued by the governor in light of the pandemic. It was issued in the spring of 2020. The language is almost identical to the language found in many of our surrounding states, and it would allow real estate transactions to go forward in a remote way. The executive order allowed notaries to witness documents remotely, and then if those documents were executed with an ink, with a pen, then they were to be converted into an electronic document. This was not used in Connecticut to close real estate loans. The vast majority of loans were not closed using this method. Lenders were not comfortable. A lot of the secondary mortgage market was concerned about security aspects of taking a paper document, witnessing it being signed with remote technology, and then converted into an electronic document. So I think the Secretary of State's office said they have another bill pending that would deal with remote online notarization. That bill is 6604. It's in front of the Commerce Committee. Will be a subject of a public hearing on Thursday. So I would urge the committee to delete section 35 through 37. They were never intended to be made into a statute.
Thank you, Mr. Hogan. Is there a comment or question from members of the committee? Is there comment or question? I do not see any. Thank you very much for sharing your testimony with us today. I hope you enjoy the rest of your day.
Thank you.
Next on the list, we have Daniel Krish, followed by Nicole Clarice Ditria, followed by Kate Wall, followed by Heather Lang. I do not see Mr. Krish. Is Representative Clarice Ditria?
Yes, I am.
You have your 3 minutes.
Thank you, Mr. Chair. Co-chairs Winfield, Staffstrom, ranking members Kissel, Fishbein, and distinguished members of the Judiciary Committee. Thank you for allowing me to testify to support Senate Bill 919, an act concerning immunity from criminal prosecution for a minor who possesses alcohol when the minor seeks emergency assistance to prevent the death or seriously injure of another person. If passed, this proposal will provide immunity from criminal prosecution for a minor who possesses alcohol when the minor seeks emergency assistance to prevent the death or serious injury of another person by repealing and amending section 30-89 of the general statutes. You have the rest of my testimony, and I just want to give you some background on this. For those of you that may not know, I'm an athletic trainer at Laurelton Hall High School, and a couple student athletes of mine that are members of YAG, Youth in Government, discuss their policies that they want to pass every year in YAG. So they came to me, Claire Bolash and Juliana Darcy, last year as seniors in high school, and told me about this Indiana Lifeline law. As we discussed it, I said, this is a great idea. I think this is legislation that should pass in Connecticut. So I said, do you mind if I try and pass this on your behalf? You can come up and testify. Well, we know what happened with COVID and we were shut down. And now the two of them are freshmen in college at Tufts and Roger Williams. So I'm doing this on their behalf and all the kids and minors that could benefit from this legislation. Thank you.
Thank you, Representative. I see Representative Fishbein. You may proceed.
Thank you, Mr. Chairman. Good afternoon, Representative. We know who the legislation is submitted on behalf of and for. Can you just briefly explain how this law would apply? What would it do?
They'd have to hit 4 factors. They'd have to, the bill would prohibit prosecution of a minor possessing alcohol under 4 conditions. Law enforcement first learns of the violation after the minor is called 911. The minor was the first person to call 911. The minor provides his or her name and other relevant information, and the minor remains at the scene until law enforcement or emergency medical personnel arrive and cooperates with them at the scene.
So this law would apply to, let's say, a motor vehicle accident. We're talking about the scene, that kind of stuff.
Yeah, well, they would have, yes, I believe so, as long as they call as soon as it happens.
Okay, thank you. Thank you, Mr. Chairman.
Thank you, Representative. Representative Callahan.
Thank you, Mr. Chairman. Good afternoon, Representative. It's good to see you here. Thank you for your time and for your work with this age group. I have 2 college students and a 16-year-old who just got his license, and had this conversation just the other day with him about his responsibilities. He's captain of the ship, and I appreciate you bringing this forward and getting your students involved in government. We need more of that. Thank you.
Oh, thank you, Representative.
Thank you, Representative. Representative Paul.
Thank you, Mr. Chair. Representative, it's good to see you. Do you know if the 2 young women on whose behalf you're advocating had an experience that led them to want this legislation to get passed? Did something happen to them? Do you know?
Not personally, but being high school seniors at the time, they've had friends that this had happened to before, and knowing that minors die of the situation, unfortunately, often every year. This is another way to prevent a death.
So in other words, we're trying to hold these kids harmless for their own actions if they report and do the responsible things, as the 4 steps that you elucidated, to prevent harm to others. But I mean, this is really about having them avoid being held, being blamed for their own behavior if they're doing something in service to a greater good. Is that what?
Right, because they're afraid that they're going to get in trouble because they're underage and drinking. But at the end of the day, it will save their life or their friend's life by calling 911.
Right. Does it only include alcohol, or would it also include marijuana?
This one's alcohol.
Do you think that there might be a reason to extend it to include marijuana? I'm just curious what your opinion is.
I don't know at this time. Just obviously, one, we don't know what's going to happen with the legalization of marijuana.
Right.
And as far as stopping and being able to determine whether someone's under the influence, or just being able to call. So I don't know, but that's definitely worth further discussion.
And last question, and this is not a gotcha. I'm just really wondering if we have any data about how often young people are hesitant to call for help out of this fear. Do we know how common this problem is?
I do not know. I don't know what the stats are. I think someone may have, I thought someone did post that somewhere. I could find and get the information back to you.
Mm-hmm. Well, thanks. It's just, I think it sounds like a really sensible initiative, and I would love to see us reduce any harm that we can to young folks. And similarly, I believe Rep. Gilchrist there is a similar situation when people are arrested for sexual crimes, and that if they could come forward and help prevent trafficking and not be charged with something minor or something that they were coerced into doing. Not exactly the right analogy, but similar in the sense that for the greater good, they might be able to get something lesser if it prevented greater harm elsewhere. So I think it sounds like a really good initiative.
Yes, thank you, Representative.
Thank you. That's it, Mr. Chair. Thanks.
Thank you, Representative Hall. Representative Blumenthal.
Thanks, Representative Claritas Ditria, for bringing us this bill. I just had a question or two, and I apologize if you answered it previously and I missed it. This bill would only cover any criminal prosecution for the possession of alcohol itself, correct? And no other wrongful conduct?
Just alcohol.
So if the individual had engaged in other potentially criminal conduct, this bill would not affect any prosecution for that, would it?
Correct. This bill is just for alcohol.
All right. Thank you for your answers and for bringing us this bill. I think it's very sensible, and appreciate your work on it.
Thank you, Representative.
Thank you, Representative. Is there a comment or question from other members of the committee? Comment or question? Seeing none, thank you, Representative Claudia Ditria, for joining us today. I hope you enjoy the rest of your afternoon.
Thank you, Mr. Chair.
Next, we'll hear from Kate Wall, followed by Heather Lang, and then Jonathan Anderson. Ms. Wall, you have your 3 minutes.
Good afternoon, Senator Whitfield and Representative Statstrom, Senator Kisco, and Representative Fishbein. My name is Kate Wall. I'm the town clerk in Berlin, and I'm also the first vice president for the Connecticut Town Clerks Association. Connecticut Town Clerks Association supports Raised Bill 6605, sections 22 through 27, dealing with the trade names. I know that Mr. Drake testified about this earlier, and the new language would help with so many problems that the town clerks have with trade names. Current law does not allow a name to be amended or to be terminated. This new language would allow that. It also sets up a uniform application, so all the towns are dealing with the same application rather than our normal way of 169 ways of doing the same thing. Also, if we could have the central database with all the trade names into it, this would help with consumer protection. People would be able to go to the trade name index through the Secretary of State's website and be able to find who are the people behind that trade name. A couple months ago in my office, we had a phone call from a gentleman who was trying to find a company that had done some work on his house. We were the third town that he called trying to find the trade name. Unfortunately, we didn't have it either, and I don't know how many other towns he had to call. This would be a very consumer friendly way of getting the information out to individuals that the name is much like an LLC or the other liability partnerships, that way they can go to the website, see the trade name, see the people behind the name. So thank you very much for your time. Thank you for your service, and have a good afternoon, everybody.
Thank you very much, Ms. Wall. Is there a comment or question from members of the committee? Is there a comment or Representative Veach?
Good afternoon. I just wanted to make a comment. Kate, I would be remiss if I didn't say hello and thank you for coming on. Okay, certainly support this. Have a good day.
Thank you.
Thank you, Representative Veach. Is there a comment or question from any other member of the committee? Comment or question? I do not see any. That being the case, Ms. Wall, thank you very much for joining us today. Hope you enjoy the rest of the day.
Thank you.
Next, we have Heather Lang, followed by Jonathan Anderson, and then Colleen Burney. Heather Lang.
Good afternoon. My name is Heather Lang, and I'm the Vice Chair of the Estates and Probate section of the Connecticut Bar Association. I am testifying today on behalf of the section, and in particular, I am testifying with regards to sections 35 and 36 of HB 6605. Remote notarization is a complicated issue and requires careful thought and consideration. Procedures that work for one area of law do not necessarily work for another area of law. We as a section and as estate planners recognize the value of being able to execute documents requiring a notarial seal when the person seeking the notarial act cannot be physically present with the notary public or commissioner of the Superior Court. We are, however, very concerned about the possibilities of fraud or undue influence with regard to the execution of wills or durable powers of attorney in particular. We are also concerned that the technology requirements to adhere to this legislation may make it difficult for certain populations, perhaps the populations most in need of our assistance at this time, to participate under the statute. We believe that some changes may be required to the legislation with regard to estate planning documents. Any document, the validity of which may be called into question after the death or incapacity of the signing party, may require different rules than those required for a business transaction or a school form. My comments today are with regard to the application of this legislation to those estate planning documents. As you all may be aware, a will is duly executed when it is in writing, subscribed by the testator, and attested to by two witnesses who subscribe in the testator's presence. Section 35 does not change the requirement that the witnesses be in the presence of the testator. And we believe this requirement to be beneficial in preventing the fraud and undue influence that is of utmost concern to us. Section 35 would permit the notarial officer and the person executing the document remotely to be the witnesses to the will. So in the case of a will execution, the person executing the document would be the witness, not the testator. At the testator's request, the witnesses may execute a self-proving affidavit, and the self-proving affidavit prevents the witnesses themselves from having to come into probate court when we are trying to submit a will for probate following death. The notarial requirement for the self-proving affidavit would permit the witnesses would be permitted to adhere to those requirements as set forth in the legislation and to fulfill that purpose, but they would not change the execution of the will itself and the validity of the will itself upon its execution by the testator. With respect to other estate planning documents which may require a notarial seal, such as a durable power of attorney or retirement plan beneficiary designations, Section 35 may only be helpful to a sophisticated client with access to certain technologies. It may not be beneficial to seniors or other persons without such access. For instance, the notary and the person seeking the notarial act may be able to communicate simultaneously within the meaning of the statute via a person's cell phone. Some clarification is needed, however, as to how the client would return a legible copy of the signed document by electronic means, pursuant to paragraph 5. Is a photo of the document taken with the cell phone sufficient to meet these statutory requirements? Does this client need to return all of the pages of the document or just the signed pages?
I'd like to advise you, your time has elapsed. If you could summarize.
Well, we believe this bill to be a step in the right direction. We think some modifications would be required if this legislation is intended to apply to estate planning documents or is intended to assist the elderly, the homebound, or those with limited mobility and access. Thank you for your consideration.
Thank you for your testimony. Is a comment or question from members of the committee? Comment or question? I do not see any. So I'd like to thank you for joining us and offering your testimony today, and I hope you enjoy the rest of your afternoon. Next, we'll hear from Jonathan Anderson, followed by Colleen Burney, and then Richard Colbert. Jonathan Anderson, you have your 3 minutes.
Thank you very much. Senator Winfield, Representative Stanstrom, other members of the Judiciary Committee. My name is John Anderson. I am speaking today on behalf of the Real Property section of the Connecticut Bar Association in opposition to House Bill 6608, an act concerning real estate abutting a right-of-way. The section opposes this bill because it seeks to overturn over a century's worth of common law regarding the ownership of private rights of way. It does this by transferring vested interests in those rights of way, and does that without due process and without compensation. It seeks to do legislatively what can and should be done by a judicial proceeding. It does not give the protections that a judicial process would provide. For example, property can be taken by adverse possession, but in order to do that, there has to be a judicial determination regarding the ownership of that property. And without that, the party claiming adverse possession does not obtain marketable title. Title can also be taken by way of eminent domain, but in that particular case, any kind of condemnation has to, again, adhere to a particular process, and compensation needs to be paid to the property owner. This particular bill has nothing like that. The property or this particular proposal would be objectionable if it simply acted prospectively. But this particular bill also seeks to affect property retroactively. For example, if the owner of the fee interest in the right-of-way had previously conveyed out all of the properties adjoining that private right-of-way, then if and when this bill becomes law, the interest that that record owner has in that private right-of-way could automatically transfer to all of these owners adjoining that private right-of-way, again, without any kind of process or compensation. If the ultimate purpose of this bill is to give the owner, or rather the holder of a right-of-way, the enhanced ability to exclude those who do not have a right to use that same private right-of-way, then a much more narrowly crafted bill can be considered to accomplish that specific purpose. However, this particular bill will give rise to both foreseeable and unintended consequences, and will very likely be challenged. So with that, that finishes my testimony. I thank you very much for hearing me, and I'd really be happy to answer any questions you have.
Thank you, Mr. Anderson. Is there a comment or question from members of the committee? Comment or question? I do not see any, but thank you very much for joining us today and offering your testimony. I hope you enjoy the rest of the afternoon. Have a great day. Next, we'll have Colleen Burney, followed by Richard Colbert, Timothy Fisher, and Stephanie Robert. Colleen Burney, you have your 3 minutes.
Thank you. Good afternoon, Chairman Winfield, Chairman Staffstrom, and members of the Judiciary Committee. My name is Colleen Burney. I am speaking on behalf of Council for AFSCME Local 749, which represents 1,600 judicial branch employees. I have been a court recording monitor in the Fairfield-Bridgeport District for 13 years. We ask your assistance in the writing of House Bill 6505, an act concerning court operations. Our union represents the almost 200 court recording monitors throughout the state. These monitors have the vital job of keeping the record and producing accurate transcripts of what is said in court, in addition to performing other duties related to protecting and making a record. Our union has been in negotiations with the judicial branch management regarding the way court recording monitors work and how transcripts are produced. We have been working tirelessly with the branch, trying to gain ground lost due to COVID, and we are close to an agreement. Our union is concerned that if there is no final agreement before this bill passes, the monitors will be privatized out of our jobs. If negotiations break down with the branch, we will ask that sections 42 and 43 be removed. We respectfully ask that we can keep you apprised of our progress with negotiations with branch management. Thank you for consideration.
Thank you, Ms. Burney. Is there comment or question from members of the committee? Comment or question? I do not see any. I want to thank you very much for joining us today and offering your testimony. I hope you enjoy the rest of your day.
Thank you. Thank you for your time.
All right. Next, we'll hear from Richard Colbert, followed by Timothy Fisher, Stephanie Vauberge, and Adrian Mong. Mr. Colbert, you have your 3 minutes.
Thank you and good afternoon. My name is Richard Colbert. I'm a partner at the law firm of Day Pitney, where I practice in the area of real estate litigation. I'm here to testify on behalf of Raise Bill 6608. A few years ago, I learned of an interesting statute in Massachusetts known as the derelict fee statute. The word derelict in this context meaning forgetful. So in other words, the forgetful fee statute. I did quite a bit of research on this statute, and I learned that the primary purpose was to settle unknown ownership to numerous private rights of way throughout Massachusetts, where the original owners conveyed away land abutting a right of way, but unknowingly failed to convey their ownership interest in the land for the right of way itself. The failure to convey ownership in a right of way typically involves owners that developed lots 75 to 100 or more years ago. The owners have since passed away, and most, if not all, of their heirs are gone as well. The ownership of these ways is essentially lost in time. I thought public policy in Massachusetts of settling and clarifying ownership to all such orphan roads, as they are sometimes referred to, was an important policy that the state of Connecticut could benefit from. I therefore contacted Representative O'Day and asked if he would be interested in pursuing a bill in Connecticut of this nature. He agreed it was a good idea, and we drafted a proposed statute that was nearly identical to the Massachusetts statute's language. We then began soliciting thoughts and opinions on the bill from the Connecticut Bar Association's real property section, as well as from Connecticut title companies. Through this process and their keen insight, we realized that while the language of the Massachusetts bill is good, Connecticut might be served by a differently worded statute. As a result, we worked with representatives from the groups I just mentioned, and they worked within their own organizations to arrive at a current draft that, while different from the language of the original proposed bill, solves the same problem, but in a more focused manner. I think all of the folks that worked on the language of this bill believe it serves a good purpose. And we all worked hard to make sure that by fixing the private orphan road issue, we did not unintentionally create other issues. As you can see, the statute is very specific in its operation and its application. I also just heard the testimony of Mr. Anderson on behalf of the Connecticut Bar Association's real property section. I happen to know that that section of the bar voted on this bill about 2 weeks ago when the original bill was before you. Since that time, I personally have worked with people from the Connecticut Bar Association and title companies to revise the language substantially. In addition, I spoke with people from CADEC, where I know Mr. Anderson works, so I'm not sure exactly how familiar he is with the current status of the language of the bill. But I do think that the language of the bill now addresses many of the concerns that I think he probably just raised. And I think they were good concerns, but I think we've done a lot of hard work to address those concerns. So with that, I know my time is limited. If anyone has any questions about the bill itself or anything else that Mr. Anderson said in opposition to the bill, I would be glad to address those questions or concerns. Thank you very much.
Thank you very much. And Representative O'Day.
Thank you very much, Mr. Chair. And thank you, Rich, for coming and testifying before the committee. And just to be clear, so we had heard the concerns of the CBA through a number of attorneys who work for title companies. And we've spent the last week, 10 days working on that language, correct?
Absolutely.
And so in a sentence, my understanding is all we're trying to do is associate ownership to private roads that have essentially been abandoned. Is that a fair sentence on the summary?
It is. I wouldn't use the word abandoned because there's a statute that relates to abandoned for public roads, but essentially you're right. These roads have been abandoned in the sense that the people who own them, they are gone. Their heirs are gone. Their heirs have no idea that they even own these roads if they're still alive. And many times I don't think they even want these roads because, again, and to put this in context, these roads are, they're laid out roads. It's not like property that's just unspecified as to what its use is. It's specified to be a right-of-way with property upon it. And so the use of the road no longer has any meaningful use other than as a right-of-way. So when you talk about things like unconstitutional nature of taking property, there's really nothing being taken here. The owner of the property can't use the property for anything other than the right-of-way. And so they don't even want it these days, I don't believe, because they take on responsibility for a road, but they don't benefit from it all because they don't live here. They live in California, they live in Utah. They have no interest in this.
And this is addressed to, in many cases, roadways were developed 50, 100 years ago, correct?
Yeah, absolutely. You know, the common law here that is at issue is something that was developed in Connecticut back in 1909. And it's interesting that back in 1909, the Connecticut Supreme Court looked at the law from Maine and looked at the law from Massachusetts, where I referenced that I got this idea from. And for better or for worse, the Connecticut Supreme Court at that time decided to go with the law from Maine, which is the law we have now. Back then in 1909, this wasn't an issue. The people who developed these roads were alive, they owned the roads, and there was no problem. Fast forward 100 years forward to now, there's a problem. There's dozens, maybe 100 roads in the state of Connecticut, I'll bet, where the ownership is simply completely unknown. And it will solve a lot of problems as it has in Massachusetts, where there are disputes over the road involving many types of issues due to the lack of ownership knowledge.
Well, thank you very much, Rich, and thank you, Mr. Chair, for your indulgence. Thanks.
Thank you, Representative. Representative Doucette.
Thank you, Mr. Chair, and thank you, Attorney Colbert. You mentioned there's some revised language that's been worked on. Has that been, I assume it's not reflected in the current version of this bill. Is that correct? Is there other language that's been submitted to the committee? Or no, is this bill what you were referring to as the product of your discussions and with the other groups?
Yeah, I'm not sure exactly what you're looking at, but I know on Friday last week, a new version, not a final version, but a very close to final version, I believe, amongst all the people that worked on it, was submitted to Representative O'Day. Whether that got uploaded or not into, where you see, I'm not sure, but I think it probably has been. Yeah.
I'm guessing not.
Representative Doucette, I believe that Representative O'Day has an answer to your question, so I'm going to allow him to respond.
Okay.
Thank you.
Thank you, Mr. Chair, very much. And Representative Doucette, yes, you do not have the, I sent the language that we got Friday to actually Senator Winfield. I'm not sure I got it to you. I think I got it to Representative Stafstrom. Our goal is to continue working on it. I think we're close to final agreement, or at least answering all the issues that were brought up by the CBA, but I've promised to work with them, and I'll get that around to the chairs so that they can get it to you. I think some have it, and I'll make sure you get it, and the rest of the chairs get it to spread out to hand out. But I know what you have in front of you today is not the final language that was worked on, but I will make sure the chairs have it and spread it out.
Good.
Thank you, Representative.
Yeah, no, thank you, Mr. Chair. Yeah, I appreciate that. I assume that was the case, and would definitely want to see that, and we'll want to get that to John Anderson, who just previously testified. I'm a real estate attorney and a CADIC agent, and John is someone I've known for a long time and trust his judgment. He's one of those smart guys that we call when we get stumped on on a title question, so we don't get in trouble. So would definitely like to have him see that. And just so I understand too, because when I read the bill, I was a little confused. Then I saw that the purpose, the stated purpose of the bill, which is on the website but not in the text of the bill, it talks about orphan roadways. So I understood a little better what we were getting at. But just to flesh this out a little more. So, currently, if a property is transferred, that right to a private roadway of the owner is an appurtenance, is basically part of the fee interest of that conveyance, is it not?
Typically, what happens is when the property is conveyed that is pertinent to the right-of-way, the deed will say in it, and a right-of-way to use the road from X point to the shore, or whatever it might say. So yes, ordinarily that would be in the deed of the party who purchases property that's abutting the way, which is an indication, of course, that the road was intended to be a private right-of-way, because there wouldn't be no need to give someone a right-of-way over a road that was intended to be public.
Right, but even in the absence of that, isn't it implied to provide legal access to that property? And that if it's part of the fee interest of the grantor at the time they convey it, it also conveys, unless it's specifically excluded. Isn't that right?
I don't think the law in Connecticut is that way. If you, under the current common law from back in 1909, if you convey property and you don't convey any part of the road, you get your property, but you don't get any ownership in the road. You get a right of way over the road. If it's not given to you expressly in the deed, you would have an implicit right of way over the road, because you need to have access and you'd be landlocked in most cases. So one way or the other, you would absolutely get right of way over the road. In addition, this bill doesn't do anything to change that. In fact, it specifically will state that whether the fee is transferred as operation of the statute or not, everyone abutting the road has a right of way over the road. So that would clarify in many instances, if there are circumstances where people don't have it in their deeds for private roads, they would now get them once the statute was applied.
Right. Now that makes sense. And then, the sort of intertwined concepts of easement by necessity, prescriptive easements, and all those sorts of things that go into that. So yeah, okay. I look forward to seeing the updated language and be happy to work with you, Representative O'Day, on that. Yeah, I think the concept is a good one, but it has to be pretty narrow to not, cover any sort of unintended consequences. So, all right, thank you, Mr. Chair.
Thank you, Representative. Are there comments or questions from other members of the committee? Comment or question? I do not see any. Mr. Colbert, thank you very much for joining us today. I hope you enjoy the rest of the afternoon.
Thank you very much.
Next, we have Timothy Fisher, Stephanie Roberge, Adrian Mong, Michael Diamond. Do not see Mr. Fisher. And I do not see Ms. Roberge. Adrian Mong.
Good afternoon. Senator Winfield, Representative Stafford, members of the Judicial Committee. I want to thank you for allowing me the time to express my support for the raised Senate Bill 939, an act providing immunity from civil liability to a physician who accompanies a SWAT team. My name is Dr. Adrian Mong, and I live at Woodbridge, Connecticut. I'm a trauma surgeon at Yale since 2008, and since 2013, I have been volunteering with the North Haven Police Department and their regional SWAT team that serves 6 towns. As you heard, the collaboration between health professionals and police special response team is a growing trend in this country. And it is born out of realization that there are situations in which normal emergency medical services simply will not respond to provide life-saving care until that scene is declared safe. Depending on what the situation is, take, for example, an active shooter in a large office complex, that can take hours. And such delays in medical care can literally mean the life or death of an injured individual. The health professionals on the SWAT teams are specifically integrated so they can provide care not only to law enforcement, but also bystanders, as well as suspects in these situations. And most of the physicians that are part of SWAT teams that I'm aware of across the country volunteer their time without any kind of compensation. I think it is important that we recognize and support these collaborations, and this act, which provides some protection to those who volunteer in these positions would be a demonstration of such support. Thank you again for letting me express my support for this bill, and I hope you will consider supporting it as well.
Thank you. Are there comments or questions from members of the committee? Comments or questions? If not, thank you very much for joining us and offering your testimony. I hope you are able to enjoy the rest of your day.
Thank you.
I see that Timothy Fisher is here. You have your 3 minutes.
Thank you very much, Senator Winfield and members of the committee and Chairman Stafstrom. I speak in favor of House Bill 6548, the recommendations of the jury task force on which I was privileged to sit, and serving as co-chair of the data subcommittee along with Attorney Claire Howard. I'd like to make 2 points. The first relates to the data that we are going to be able to collect regarding jurors under this bill. At present, we are not able, the judicial branch is unable to track exactly where we lose people between the process of the summons and the questionnaire and the actual jury service. And this will enable the branch and researchers to track every step of the way and where it is that juries become less and less representative of the citizenry of Connecticut. These questionnaires will continue to be available to counsel at voir dire, but will have all personal identifiable information removed and anonymized for purposes of research by the branch and others. The second point I'd like to address relates to the statutory exclusion currently under Connecticut law of former felons for a period of 7 years following the end of their incarceration. This rule, however well-intentioned when originally adopted, runs contrary to the historical trends in America of increasing and broadening the rights of citizenship. Perhaps not surprisingly, the trend of this particular rule around the country tracked the expansion of Jim Crow restrictions against racial minorities and African Americans especially. But most importantly, we now recognize that it is not helpful. And the best demonstration of that is in our neighboring state of Maine, which has never excluded felons from jury service. And so I've communicated with senior members of the judiciary in Maine, and the lesson I've heard from them and the message clearly from them is threefold. Number one, it doesn't present a problem to them at all. They are very content with the absence of any blanket exclusion of former felons. In fact, what they say is that they actually rarely are aware, mostly because it is rare that prosecutors move to exclude somebody for cause or peremptory reasons for being a former felon. What they actually say is that prosecutors tend to find potential jurors' Facebook postings far more relevant to any grounds for exclusion of a juror than their past criminal history. Second is that jury service by former felons correlates with the reduction of recidivism in Maine, which is understandable because what it does, among other things, is convey to that individual that they are appreciated and integrated into society. And that's a very positive consequence of such a change. And third, it is generally known as it's a social law that diverse groups make better decisions. And in fact, experiments have shown that white jurors make fewer errors and they're more careful when they serve on a jury with people of differing backgrounds and differing races. In fact, in a way that is recapitulating the very point the Chief Justice made at the start of our hearing this morning, that in formulating this task force, he intentionally brought in people from highly different backgrounds and perspectives and opinions, knowing that by listening to each other, we would arrive at a better decision. And the same can be said true of juries. The more we create diversity, the better we'll get as outcomes. Thank you.
Thank you, Dean Fisher. Are there questions or comments from the committee? Seeing none, thanks for being with us today.
Thank you.
Okay, I don't believe Michael Diamond or Kathy Flaherty are with us. So next up will be Paul Keeley. Is Paul Keeley with us? Carolyn Carvalho.
Cavolo, thank you. Thank you, Senator Winfield, Representative Staffstrom, and members of the Judiciary Committee. My name is Carolyn Cavolo, and I am the current Vice Chair of the Real Property Section of the Connecticut Bar Association and Counsel at Shipman and Goodwin. Our section has a position in opposition to any remote notarization legislation, and I'm here today on behalf of my section to offer testimony in opposition to sections 35 through 37 of Bill 6605. I appreciate that Mr. Drake earlier today requested that the committee remove sections 35 through 37 from this bill and stated that the debate over remote notarization should stay within the discussion of his department's proposed bill number 6604, which is before the Commerce Committee and deals exclusively with remote notarization. We concur with Mr. Drake's request and support that request. Sections 35 through 37 of House Bill number 6605 codifies the temporary emergency measures provided for in Governor Lamont's executive orders. The language of the executive orders was never intended to live on as permanent legislation and is insufficient to protect consumers from fraud. Additionally, it also potentially conflicts with Public Act 1988. We urge the committee to remove sections 35 through 37 from Bill number 6605, and we will offer further substantive testimony in opposition to remote notarization in connection with the hearing for Bill number 6604. I'm happy to answer any questions any of you may have. Thank you, members of the committee, for your time today.
Questions from the committee? Seeing none, thanks for being with us.
Thanks.
Paul Garlinghouse.
Good afternoon, Senator Winfield, Representative Staffstrom, chairs of this committee, distinguished members. I'm a family law attorney, primarily practicing family law in the New Haven area for the last 20 years, and I am speaking in opposition to specific parts of raised House Bill 6505, the Court Operations Bill. Particular sections that I'm testifying about today are sections 19, 20, 21, and 22. In general, what these sections have in common, and Judge Michael Albus talked about this a little bit earlier, is allowing for proceedings by affidavit in lieu of the normal process where the parties have to appear in court. Traditionally, that was actually physically in court, but these days, you know, they do it over Microsoft Teams, which has been a great adaptation that we've had. And they have to be sworn in, and they have to be canvassed by the judge. The questions the judge asks are generally the same questions. If you have a pro se person, you're asked if, you know, you're comfortable representing yourself. By agreeing, they're waiving their right to a hearing and all of the protections of the adversarial process. The judge asks about that. Crucially, the judge always asks, has anyone threatened or promised or forced you in any way into signing this agreement? And the judge is able to, even remotely, look the parties in the eye and hear their answers. Now, in my 20 years of practice, I have seen it. It is not unheard of that after all of this work, we drew up an agreement and the client stands in front of the judge asks, is this a fair agreement? And the person says no. At which point the judge then asks a lot more questions and usually sends us back to the drawing board. Judge Albus represented to you that these proceedings by affidavit only, and as I read it, and I can't even believe this is true, it says affidavit of one party would be enough for these final decisions to be made in these family law cases. Affidavit of just one party, that's incredible. It is unconstitutional because, you know, these people are being denied the chance to, you know, confront, you know, and cross-examine and all of those other things, but it's not even efficient. How does the judge know, based on one affidavit or even two affidavits, that there really is an agreement of the parties? There is unequal power in a whole lot of family law cases. These cases are fraught
people are upset. They are not at their best. And sometimes they lie and misrepresent and do things that they wouldn't normally do in other circumstances. Now, it is no remedy at all that they're making affidavits under penalty of perjury. The prosecutions under those either misdemeanor or other statutes are exceedingly rare, and the courts don't have enough time in the year or the century to deal with all of those disputes. So that does not happen. But this procedure would result in people having undue influence. You have to sign this agreement, or else I'm going to take the kids. You have to sign this agreement, or else I'm going to bankrupt you. You have to sign this agreement.
Sir, I just need you to wrap up your 3 minutes of
Yes.
expired.
So I'm asking you to please not institute a procedure that's going to lead to people being deprived of their rights. And in the end, when these cases finally come back, it's going to lead to less efficiency in the court system. Thank you very much for your attention.
Thank you. Questions or comments from the committee? If not, thanks for being with us and offering your testimony. Deborah Rule.
I am here.
Hey, go ahead. You have 3 minutes, ma'am.
I didn't know if I could unmute myself. My name is Deborah Rule, and I practice law in the family law area. And it saves you time that I'm following on the heels of Mr. Garlinghouse, because I am here to support the position adopted by the family law section of the Connecticut Bar Association Executive Committee, particularly with their opposition to legislation permitting the judiciary to amend statutes to allow the judiciary to remove testimony regarding family law matters and rely on the use of affidavits. And I am remiss in not opening and saying I'm pleased to appear in front of this committee and the members of the committee, and appreciate your attention. The concern is the constitutional issues in having access to justice. The concern is that if you waive that right to access to justice, it should be a knowing waiver. And it's important to understand, for example, my practice is a lot of collaborative law. I appreciate and support the ability for self-determination and autonomy for divorcing couples. This is not about trying to make sure that lawyers have access to the court. It's quite the opposite. But to ensure that that waiver is knowing and intelligent, there should be a step in between. Either the parties agree to file an affidavit together, and that would be, in my view, appropriate, or they should at least see trial referees or family relations, not for the purposes of usurping a function of reviewing the agreement, but for the purpose of making sure that people understand they do not have to sign an affidavit, and they can go before a judge to accept and review their agreement. It is really to ensure, especially that folks who are not represented, which my understanding is over 80% of the cases in family court have at least one person who is not represented involved. To make sure that they understand that. Also to remove any claims of duress. It might be fertile ground for people later to claim that they were under duress when they submitted the affidavit. There was a case recently where someone was in the next room with a victim of their duress, so to speak. So fair access to justice is what I want to bring to your attention, making sure there's at least a boundary in between signing affidavits and waiving the right to see the court. Thank you very much. I appreciate your time and attention this afternoon.
Thank you, ma'am. Questions or comments from the committee? Seeing none, thanks for being with us.
Thank you.
Gerald Gray.
Am I on?
We can hear you, ma'am. We can't see you.
I don't know why.
If you
To you.
do you have the camera button on your
Start
bottom?
my video. Okay, that just came up. Let me see if that works.
There we
Okay.
go. We got you.
You right? Okay.
Yep.
Good afternoon, Judiciary Committee at all. I am Daryl Gray, and I am testifying today in opposition to Bill 959, 6505, and 940, each of which are acts concerning probate court operations. I have provided written testimony here, which I would very much hope you read. And in the past few weeks of this session, I have submitted and provided oral testimony and other bills regarding Connecticut probate court operations. These being bills in the Aging Committee and the Labor and Public Employees Committee. With the 3 minutes I am allotted to speak here before you, I cannot adequately parse and review the objectionable specifics of these bills, as the bills are indicative and representative of just one more contributing factor in the comprehensively and all-encompassing issue of the entire malignancy of the probate court enterprise. Our U.S. Senator Dick Blumenthal has properly identified the core essence of what is wrong and corrupt and malignant about the probate court enterprise. The problem lies in the probate court judges, whom Senator Blumenthal informed and testified before the entire nation are in his home state of Connecticut and clearly in probate courts in other states, running secret fiefdoms wherein these judges are making tons of money by gaming the system, which they have structured to enable themselves and their crony insiders, these being the fellow members of the probate conservatorship, guardianship, elder law, social services, racketeering, human trafficking enterprise to operate in secrecy and without transparency or accountability in this rigged gang-style operation to predatorily grab the money and assets from prey who possess such money and assets so as to pocket the money for themselves. They then account to the state for the little money and no money probate cases that come before them with the tiny fees that they then charge for handling those cases. And the state thus has a small budget for the probate court. Everybody looks good. Probate judges and their cronies make many millions of dollars by robbing the assets of those who have assets while pretending to the state, which gladly puts its hands over its eyes, that the budgets and expenses for handling the little money and indigent cases is very low. So it is the Connecticut people with assets and ultimately Connecticut taxpayers who are getting screwed as the probate robbed prey become indigent and then have to be supported by the Connecticut taxpayers. Connecticut probate court enterprise is a self-profiting, self-contained closed system, a self-profiteering system that is the same as any of the worst of mafia and drug cartel mobs, as it destroys so many thousands of lives of its targeted prey for its gang members' own self-profit. And by keeping the clerks and other probate court workers as not being state employees, the judges can control and use them at will, just like every other mob boss does to the mob underlings. Senator Kevin Kelly's bill.
Ma'am, I have to interrupt you. We're at the 3-minute mark. If you could just conclude your testimony.
Okay. I'll talk about Kevin Kelly's bill 940. This is just another most indicative example of the unbridled predation and abject corruption of Connecticut probate court, giving such overreaching power to the probate courts and their judges. In the context of this bill, that Kevin Kelly has been operative in already putting in place the power of probate judges to, at their own discretion, have one of their complicit cronies in DSS Protective Services.
Thank you, ma'am. Thank you, ma'am. We've got to leave it there. Are there?
Can I ask for any questions?
I'm going to. Yeah. Are there any questions or comments from members of the committee? If not, we want to thank you for being with us today, ma'am. Madam Administrator, did we miss anybody?
No, no one else is in the waiting room to speak. We're all set.
Okay. All right. So we are going to conclude today's public hearing. I will remind the members that we will be back on Wednesday with judicial confirmation hearings, and we do expect votes on Wednesday. All right. Thank you all for being with us.